tagged in the file. My lord, your lordship kindly permit us so that it can be tagged. My lord, in that case, I think it is better to fix it too, because office will take some time to send it.
Okay.
Authorized.
Mr. Dutta,
My lord,
I have some difficulties. I have some assignment at 2 o'clock at Dibrugarh, my lord. So that is my difficulties actually. Is it possible, my lord, to fix on 3rd if the learned senior friend has agreed? Because otherwise I am available up to 1 o'clock, my lord. But 2 o'clock, I have a difficulty.
let us take it up on 3rd.
all right.
Okay.
Lordship.
On request.
Yes.
Item number 41. On
49, my lord.
49 on request of Mr. Hester, net senior counsel, appearing for the applicant, let this matter be listed on 3rd of October in motion item, as a fixed item in motion column.
Much.
Grateful, my lord.
May I please be my lord? Lordship, item number 16, Lordship, I would like to mention it on 3rd, or Lordship, it is for admission only. Because I am a medical checkup, Lordship. So if it can be admitted, enhancement compensation, Lordship. Or on 3rd, Lordship.
Okay, we'll admit it when the matter is called. You need not to remain.
Yes, Lordship. And then item number 38, Lordship, it's may come after vacation, Lordship. 38 also.
Request of Mr. A. R. Agarwala, learned counsel for the. You have informed the other
Yes,
side,
Lordship, I will inform.
learned counsel for the applicant, who has taken the consent of learned counsel for the respondent. Let this matter be listed
After
Oh.
vacation.
after 3 weeks on a date to be fixed by the registry.
Item number 16, Lordship.
May I please, your lordship? I beg to mention item number 18, my lord. I am appearing on behalf of A.G. Chaudhary. Today she has some personal difficulties, so matter may be adjourned for a day, my lord. Kindly fix it after vacation any day, my lord.
Okay. Heard Miss
N.
Okay.
Fukan.
M.
N. Fukan.
N. Fukon, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of Mr. A.G. Chaudhary, learned conducting counsel for the appellant. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after puja vacation on a day to be fixed by registry.
Deeply agree.
My lord, I beg to mention for listing of the CRP IO, my lord, same matter, same party, Friday taken time and in Thursday it is fixed, my lord. So some development we have helped another CRP IO. That's the
Listing you have to mention before the senior court.
May I please, I like to mention for list of this CRPs because these are connected matters have been disposed of.
No, listing you have to mention before senior court.
15.
Senior court.
I understand, but CRPs has been in this week.
You have to make that mention before the senior court. That is the rule.
May I please? Item 45, my lord. It is part third matter, my lord. And my lord, I have discussion my learned friend, my lord, of the railway council, my lord. My lord, today, my lord, it will take much time for me also and for the reviews. So that may not be possible, my lord. So immediate after vacation, any day, my lord, because not possible.
You have informed.
Yes,
counsel.
my lord, yes.
Heard Mr. S. Chauhan, learned counsel for the appellant, who prays for an adjournment. He has submitted that he has informed learned counsel for the respondent side also. The prayer is allowed. Let this matter be listed on 14th of November as part third matter.
May I please, your lordship? My lord, one item, my lord, criminal petition. Part third before this honorable court.
Part third,
Yes, no, this was fixed today, but somehow it has not been listed, my lord.
what is to be done? Who is the other side?
Can
State-
it be, can it be on my lord, third or fourth, any day as your lordship pleases?
Other side is
Criminal
the
petition, my lord, state is there,
state is there.
state is there.
Okay, when should we list it?
As your
Yeah.
lordship pleases, my lord, because this vacation is there. Our only problem is that my lord, petitioner is in jail, so they are also pressing me, my lord.
This is some NDPS matter,
NDPS matter, my lord, your lordship.
quashing of the charge sheet,
Yes, my lord,
charges.
yes, lordship has queried, my lord, whether it should be 482 or 397.
Okay, okay. Then we can hear it when only 2 days left.
Only 2 days left, my lord, so that is, I leave it to your lordship, my lord.
Let it be on Thursday.
Yes, sir. I'm online, lordship. On
Yeah.
third, my lord, on third,
On third, you have to give mention, ma'am.
my lord, that's why I'm giving. Always, lordship.
May I please, say, Lordship? Lordship, I beg to mention item number 29 of daily list.
29,
The matter
29,
29 of daily list.
yes.
The matter may be listed after vacation. Lordship. Consent has been taken.
You have taken
Yeah.
consent of the other side.
Yes, Lordship.
Third, miss, what's your name? Your
Yeah.
name,
Hera Leo,
naam to likh lo. Learned Council, you are appearing for
SK Talukdar. Respondent.
Learned Council for the respondent submitting on behalf of Mr. S.K. Talukdar, Learned Council for respondent number 1, who prays for an adjournment on the ground of personal difficulty of the conducting council. She has submitted that she has informed the Learned Council for the applicant regarding her prayer for adjournment. The prayer is allowed. Let this matter be listed after puja vacation on a date to be fixed by registry.
Worship, I beg to mention item 27 for withdrawal, your worship.
What
I
is
am
your,
for the appellant in that case,
what is your name?
AK Rai, your worship. On behalf of Mr. SP Rai.
Why are you withdrawing?
Your worship, the matter arises out of granting of an ad interim injunction in favor of the respondents. Now, in the trial court, the injunction matter has been heard and matter is fixed on 310 for final order. So,
Heard Mr. A.K. Roy submitting on behalf of Mr. S.P. Roy, Learned Counsel for the appellant, who submits that who prays for allowing the appellant to withdraw the instant appeal on the ground that as the matter has been fixed before the trial court for final hearing,
final order, your worship.
final order after hearing,
Yes.
no purpose would be served in pursuing the instant appeal. Considering the submissions made by Learned Counsel for the appellant, the prayer is allowed. This appeal is dismissed on withdrawal.
Simply obliged.
Next, please, Lordship. With the concern of other side, I beg to mention item number 36. Here, I am for the petitioner. Here, they have filed abatement petition, delay condonation, so we will file objection on this.
36.
36,
Heard Mr. What is your name?
C Talukdar.
Heard Mr. C. Talukdar, Learned Counsel for the respondent.
Yes, yes.
Also heard Mr.
S.J. Sohoria for the
S.
petition. S.J. Sohoria.
S.J. Sohoria, Learned Counsel for the applicant. Learned Counsel for the respondent prays for some time for filing written objection against the application filed by the
Yes, ma'am.
applicant for condonation of delay. The prayer is allowed. Let this matter be listed after puja vacation on a date to be fixed by the registry.
Deeply obliged.
May it please your lordship. I'd like to submit this mention memo. I had mentioned it before the court number 15, but that code is apparently not available there after tomorrow, my lord. So it's an arbitration appeal, my lord. Urgency is that, my lord,
No, you have to mention before code number 50.
I had done it, my lord. I had done it.
Then
that court will not be available on 4th, my lord. That is the problem, my lord. And urgency is that, my lord, I have come against the rejection of injunction application, my lord. It is a contract matter. Under the contract agreement, I was entitled to 2 years extension. Without assigning any reason, that extension has been refused. Only 6 months was given to me. My lord, it is going to expire on 9th of October, my lord. So I need,
When do you want?
my lord, if your lordship takes up tomorrow, it is perfect for me, my lord. Very urgent, my lord.
When have you filed?
Yesterday, my lord.
Okay, tomorrow.
My lord.
Or day after
A day
tomorrow.
after tomorrow, on 3rd, my lord. Obliging.
Item three, that will be taken up to the journal. Item
Item
three.
three.
My lord, third round of litigation, my lord, before this report. Firstly, I approached on annexure 4, page 47, my lord, will find. And the finding your lordship will find. It was against an order passed in order 7, rule 11 application, my lord.
Rejection of,
Rejection of claim. Page 52 is the operative portion, my lord, paragraph 9.
no, which order you are impugning?
Now I am impugned the order at annexure 8, page 65, my lord. Twenty-one, 8, 2024.
What is this?
My lord, it is seen that the plaintiff has filed this suit challenging so and so. In view of the fact that the defendant number 1 to 5 executed deed of development in favor of him and have sold the constructed flat to the prospective buyers, the prayer of the plaintiff directing the defendants to furnish the names of the prospective buyer is found to be justified. My lord, 400 flat owners, my lord. This will be an abuse of process of law, my lord. I have a Supreme Court judgment, my lord, wherein it is said.
No, what the plaintiff wants? He only
Plaintiff
wants,
wants and the entire people's name, my lord, 400 people. And my lord, my friend who is appearing for the developer, he has already paid me the money. Whatever money is there, it is between them.
who is the plaintiff?
Plaintiff is the son of one of the.
What is his interest?
He, without knowing that his mother retired from the farm,
He is he is son of the,
ex-retired partner of the farm.
but you are a partnership.
I am a partnership farm.
Okay.
Petitioner number 1 is a partnership farm. 2 is a retired partner. 3, 4, and 5 are the present partners.
And the plaintiff.
And the
the
plaintiff,
Respondent is also son of,
respondent is son of petitioner number 2 and a retired
son of petitioner number 2.
petitioner number 2, because petitioner number 2 and the retired partner was a husband and wife. He is claiming his mother's share, my lord. My lord, I'll take your lordship to ITR annexure 3, page
Okay.
45. Your lordship will find the
For
retired.
what purpose suit has been filed?
Suit is to insert him as a partner in the farm. First. Secondly, to interfere with the day-to-day business of the farm. Now, the very fate of the suit is in question, my lord. So we have filed objection and your lordship will kindly come to page 45. I will clarify your lordship that the partner retired. This is an ITR report. Relevant page will be page 46, my lord. It is at column 9, my lord. When the partner changes and alterations have to be recorded before the income tax office also, my lord, because we pay income tax. Now, your lordship will kindly see the bottom part, 1/20/13/4/1/4/2013. So and so is deleted, retired from farm. Your lordship has found it.
Which column?
column 9, my lord. Before 10 starts, my lord, bottom line, my lord, of 9.
DEL is this.
My lord, deleted.
Okay, this
Remarks, retirement from farm.
Swapna Banerjee.
Yes, my lord. My lord, this fact was not known to the respondent, my lord. So he approached the civil suit. My lord, as on this date, he has not challenged the retirement deed, my lord. Although we have brought it before the knowledge of the learned trial
He
court,
has not challenged what?
that particular deed of retirement.
There is a deed of it.
There is a deed of retirement, my lord.
Okay.
If he is going to put his hand, he have to challenge the deed of retirement first, my lord. It is not under challenge. Although we have filed WS categorically stated, my friend has also filed. Now, bringing 400 people, my lord, before the trial court is just futile exercise.
Now, why he need the names? The prayer is only for furnishing names of the
Yes, well, next step.
prospective buyers.
Yes, next step will be to implicate them and as a party in the suit, my lord. My
But-
lord will find his
But
petition.
that would be his burden, plaintiff's burden.
My lord,
How you would prejudice?
my lord, we will be prejudiced because 400 people will be before the court without any reason. Because my friend has already paid the money. Even assuming but not admitting, even the respondent is entitled for anything. He is entitled for profit and loss from my farm. Not from him, not from the buyers, my lord. Bringing them to the court is unnecessary, my lord. Judgment to be so.
No, who is he? The
My lord will kindly come to my judgment, page 9, my lord.
page?
9 of my judgment, my lord. That I have furnished my paragraph 13, my lord. It is in connection with my lord, Wakaf property, my lord. A reference quote is not so and so, so and so. I'm skipping this line, my lord. Sub paragraph will, your lordship will see 9. Even otherwise, a civil court can direct implement of a third party in a suit only in case where he is a proper or necessary party and
Yes.
otherwise have an interest in the subject of the suit. My lord, have you found it?
Yes.
Even civil court ordinarily would not entertain a petition for implement of a third party in a list pending before it, which would enlarge the scope and ambit of disputes between the parties. A civil court would also not ordinarily implement a third party as a result whereof fresh dispute, either amongst the plaintiffs inter se claiming under the same title or inter se between the defendants would be required to be determined. But it's clear, my lord. Unnecessarily bringing 400
No, but
persons.
this judgment is regarding impleadment. And the case before us is not impleadment. It is only furnishing the
My lord,
names.
I understand, my lord. As soon as I furnish the document, he furnishes the particulars of the buyers, my lord. Well, why to furnish particulars of the buyers, my lord? First of all, they are not
What was the reason mentioned in the application?
application, my lord. He says he approached this registry. Your lordship will find annexure 6, page 56. Petition.
56.
Yes, my lord.
Yes, what is this?
My lord,
This
paragraph
is the
2, your lordship.
application. Is this the application on
Yes, my lord.
impugn order was passed?
Yes, my lord. We raise objection, my lord, saying that
Why he needs?
paragraph 4, the petitioner came to know from a reliable source that defendants have already sold out some of the flats in favor of the different customers. It is necessary to mention in the suit for diverting attention petitioner as well as even the diverting attention of the honorable afforded defendant number 1 to have filed different petitions, including prayer for rejection of claim. Further, the defendant asked before the honorable court to send the matter for mediation. However, due to arrogant nature of so and so, taking advantage of such halting situation of the instance suit and the defendant will their ill motive plan to execute sale deed already sold, my lord. Paragraph 6, my lord.
page 58. After getting knowledge, the petitioner inquired before the sub-registrar about registration of any sale deed executed by the defendant in respect of the suit property. However, the plaintiff could not be able to get information about some of the sale deeds only, but failed to get entire information about some sale. Therefore, the petitioner plaintiff has compelled to file this petition praying before the Honorable Court to pass an order directing the defendants to submit all the information about the sale of the suit property, such as information about sale deeds and names of respective buyers on the next day, so that the plaintiff can take appropriate steps with regard to such new facts and circumstances. What will be the next steps, my lord? Next steps will be to include them as a party, my lord.
But that is not mentioned.
That is not mentioned.
If they
My
are,
lord, clever drafting, my lord. Now, my friend's problem will be 400 people will come before the honorable trial court without any reason.
no, only if makes him a party, them a party.
My lord.
Only if the plaintiff makes them a party to the pending suit. But that is not reflected in his
Yes,
application.
that is the reason I am saying, my lord, this is a clever drafting, my lord. The next step will be naturally, my lord, implement of them, my lord. My lord, why to furnish particulars, my lord? Interestingly, my lord, the respondent have already paid the money to us. He is entitled for only his share, my lord, 1/3 share, because petitioner number 2 and petitioner number 5 are also the legal heirs of the deceased partner. And every time he harps on ancestral property, your lordship, was already taken care of by this honorable court while passing in order dated 17/8/2022 in CRP, my lord.
So what is your objection?
My lord, my objection is, first of all, the petition is not maintainable
Why?
because it is not provided in CPC. My lord,
It
secondly,
is
my
in the
lord,
nature of discovery and inspection.
my lord, I have gone through it.
It is in the nature of discovery and.
My lord, I have gone through it, my lord. But I'll say it is not, my lord, because order 9, rule 12, my lord. No, order 11.
Order 11 rule.
I have gone through it, my lord. And secondly, my lord, the developer objection page 61, my lord. My lord, my objection page 62, your lordship will come to paragraph 7, my lord.
Yes. Order 11 does not.
My order 9, no, it's order 11, my lord.
Yes, order 11.
Rule 12, my lord. Application for discovery of documents.
He is not asking for documents.
My lord, that is also not there. That is the reason I have said, my lord, the petition is not maintainable.
In his application, he has not mentioned the reasons why
Yes.
he requires.
My lord. My lord, totally a vague petition, my lord, and learned court below, while passing the order, my lord, ignored many things, my lord. Because your lordship will, if your lordship kindly comes to annexure 5, page 54, passed by this honorable court.
What was your objection?
My lord, my objection was, relevant objection is page 62, my lord, paragraph 7, my lord. It is submitted that since the mother of the petitioner late so and so had already retired from the partnership from with effect from the petitioner has no right over the property of the defendant number one. Now, this is a partnership business, my lord, not an ancestral property,
No, we are not on that.
my lord.
We are on whether he can ask for furnishing of information regarding prospective buyers.
Secondly, my lord, that is the reason I have said the petition itself is not maintainable. The first objection was that, my lord, that is already, your lordship will find at paragraph 1, page 61 of my objection, my lord. Not in so many words, in few words, my lord. That the petition filed by the plaintiff dated so and so is not maintainable in law as well as in facts. Even and while filing the petition, my lord, the respondent has not made any statement in the petition under what provision of law he has filed. Let them come before this honorable court and
Heard Mr. H. Das, learned counsel for the
petitioners.
petitioners. This application under Article 227 of the Constitution of India, read with Section 151 of this Code of Civil Procedure, has been filed by the petitioners impugning the order dated 21/8/2024 passed by the Court of Learned Civil Judge within bracket Senior Division Number 2, Kamrup Metro, whereby the trial court, whereby the said court had allowed an application filed by the respondents, filed by respondent number
One sole respondent, my lord, because I have made pro forma respondent 1, 2, 3, and 4.
filed by respondent number 1.
Sole respondent.
No, there are pro forma
They are a pro forma respondents.
respondent number 1. Praying for furnishing all information about sale of suit property. No, not praying for. Praying for certificate, whereby the present petitioners were directed to furnish the names of prospective buyers. Stop. Learned counsel for the petitioner has submitted that the respondent number 1 has filed a title suit which has been registered as title suit number 447/2019, claiming his share in the business of the petitioner's firm on the basis of his being the successor of one of the partners of the petitioner's petitioner number 1 firm. Stop. Learned counsel for the petitioner has submitted that the predecessor in interest of the respondent number one, namely late Sapna Bishwas, Sapna Banerjee, who was one of the partners of the petitioner number one firm, is no longer the partners of the said firm, as her name was deleted in the year 2013 on her retiring from the partnership firm after executing a deed of retirement. So, learned counsel for the petitioner has submitted that who is pro forma respondent number two?
Former respondent number two is an employee of my friend's
No,
client.
this is Messrs. Shubham Bildwell.
The Shubham Builder is the builder, my lord. I will bring other petition.
Builder.
He is the developer who developed the
Item number
property
three.
and sold the.
What was the line? Learned counsel for the petitioner has also submitted that the petitioner, the petition which was allowed by the impugn order itself was not maintainable, as it was not mentioned in the said petition as to under which provision of law the said petition has been filed. Learned counsel for the petitioner has also submitted that there is no provision in the Code of Civil Procedure, not even under Order 11 of the said code, which requires furnishing of the names of the prospective buyers to the respondent number one, if same is not in any way connected with the suit pending before the trial court. Learned counsel for the petitioner has also submitted that the purpose of allowing the petition filed by the respondent number one for disclosing the names of prospective buyers has also not been mentioned in the his application. Neither same has been mentioned in the impugn order. Stop. He therefore submits that the petition filed by respondent number one is not maintainable, and the impugn order is also liable to be interfered with. Issue notice to the respondents. Since you are appearing for pro forma respondent,
Yes, my, in this case, when I am appearing for.
we are taking this.
Twist,
What is your name?
my lord. It
What-
is to whom Bildwell and.
No, what is your name?
I am, I'm P Hazarika.
Yes, Mr. P, as Mr. P Hajurika has appeared for pro forma respondent number two, no formal notice need to be
2 and 3, my lord.
2 and 3 also.
3 is the employee of him. my
You are appearing for
Yes, my lord.
2 and 3, no formal notice need to be sent to the pro forma respondents. As regards this respondent number one, the applicant, the petitioner shall take steps for issuance of notice on the respondent number one by registered post with ID as well as by usual mode within a day from the date, within 2 days from the date of
I'll
this
take it today.
order. Stop. Meanwhile, is there any prayer for interim?
Yes, ma'am.
Where? You have made prayer.
It is at page 13, my lord.
Meanwhile, considering the submissions made by learned counsel for the petitioner as discussed here in above, the operation of impugn order dated 21/8/2024 passed in title suit number 447/2019 by the Court of Learned Civil Judge, Senior Division number 2, Kamrup Metro shall remain stayed for until next returnable date. Before that paragraph, the notice issued to respondent number 2 shall be returnable on 6th of November. When is the next date fixed?
Next date, it will be. Next date is 11 November. my lord.
The 6th of November.
Obliged, my lord.
What is item number 3?
We are for the builder. Similar prayer, I am adopting the submission made by learned counsel. We have,
For furnishing the names.
my lord, same prayer. I am the dependent number 6 in the suit, my lord.
I'll accept notice on behalf of a number respondent.
Why 2 revision petitions separate?
My lord, because he is the dependent number 6 and 7. He's led by some other lawyers there. And I am
No,
representing.
but if relief is granted in your petition, he will also get relief.
Well, sometime it happens, my lord, the trial court says it's not in favor of you. As an abundant question, my lord.
Third, Mr. P. Hajorika, learned counsel for the petitioner. Baki eke thakibo.
Yes, my
Everything-
only
Rima,
that part, the petitioner,
Everything will remain
Yes.
same.
only that part, my lord, that array of respondents. I have made 1, 2, 3, 4 as like.
I'll make necessary changes in the
My
order.
lord.
Well, I'll accept notice on behalf of 1 to 5.
Last para, since Mr. S. H. Das has appeared for respondent number
1 to 5.
1 to
Not
5,
that.
no formal
Not that.
notice.
2 to 6.
2
2
to
to
6,
6, no?
no formal
Two-
notice
2 to
need
6.
to be sent to the said respondents. As regards respondent number 1 is concerned, the petitioner shall take steps for issuance of notice on the said respondent by registered post with ID as well as by usual mode within 2 days from the date of this order. Returnable on 6th of November,
My lord,
list accordingly.
my lord, what the matter may be take together.
Let this matter be listed along with CRP within bracket IO number 395/2024 on the next date fix.
Obliged.
Lord, my partition suit has been stayed under section 10 of the CPC, my lord. In view of tendency of a probation,
Aviator is there.
I'm the attorney.
You have any interim relief?
I have prayed for stay of the impugned order, my lord.
It will start, then it will give you the main relief itself. We will issue notice.
Very good, ma'am.
Third, Mr. B. D. Deka, learned counsel for the petitioner. Also, Mr. S. Sharma, appearing for the
Okay, hold it, huh?
All the respondents.
My lord, take it, sir. The sister will have coordinated something.
Appearing for all the respondents.
Well.
This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the order dated 27/2024 passed by the Court of Learned Civil Judge Senior Division Morigaon in title suit number 13/2022, whereby the application filed by the respondents, number 1 and 2 for stay of the suit filed by the present petitioner under section 10 of the Code of Civil Procedure has been allowed. Stop. Which record would be necessary?
Records perhaps
Record-
may not be necessary, my lord.
May not be required. So
Then-
only low points will be there, the record may not be required.
And we'll fix it for admission hearing.
Admission
Let it come
in
over.
the-
Let this case be fixed for admission hearing. Since Mr. S. Sharma has appeared for all the respondents, no formal notice is required to be issued to the respondent side. Is this matter?
Next one.
19th, Lord, November.
November, na? After Diwali, na? Pretty much.
You want a fixed date?
Yes, because my suit has been stayed.
Okay, 19 November, list this
Bye.
matter on 19 November.
Obliged.
The caveat stand discharge. In caveat application. I'll pass on this. Fifty. Yes.
Library. In the cases we review, I have highlighted proof, exceptional proof, in this case. And bring for injunction for a particular road. That road, size of the road, interior to my land, that is 175 in length and 7 feet, is wide. Here, first of all, I have purchased the land,
No, you have filed a suit. You are the plaintiff.
I'm plaintiff,
You are plaintiff.
I'm plaintiff.
Then
Then I filed a suit and we along with them this case for injunction for a particular plot
you
of
have
land.
filed the suit for what?
Right to the interest, I have mentioned, I have been, sorry. That should be annex on page 13. I have mentioned right to the interest. Declaration of right.
And for
title-
permanent injunction, okay.
Injunction.
Thereafter,
Then along with miscase Millard. And miscase Millard annex 2 Millard, page 22.
okay.
And in this case, on the first date, the learned court granted an interim injunction for a particular, for the after next date. Then the respondent here, the opposite parties appear in the court, and they file a objection, written objection to vacate the that interim injunction. And after hearing the parties, without any evidence, without any other document, vacated the order. So I filed an appeal, misappeal, in the higher authority. Then what happened, the learned appellate court also upheld the same order. And that last order, you may kindly see.
Which order you are impugning? Which order you are impugning? Impugn order is at which page?
Impugned order was page
77.
77, yes.
whereby appellate court upheld the order of the trial court.
My lord. And hearing my lord, the page 88, your lordship may fill on once, you know. Sorry, we have some problem. And the land appellate court discussed, my lord, there are three principles of, my lord, three golden principles for granting an injunction, that point, my lord. First of question, my lord, prima facie of the case. And it is in my favor. Page 88, has not got it. Paragraph 18.
Yes.
On perusal of the impugned order, it is revealed that the learned trial court has observed that there is a prima facie case in favor of the petitioner. There is, we are middle. As the petitioner has been successful in raising the substantial question in the suit, which needs judicial determination. The learned counsel for the appellant has contended that the trial court has rightly held that the plaintiff has prima facie case in his favor. So, Lord, there is a prima facie case, it is held by both the courts. And then another principle, your lordship may kindly see, balance of convenience, page 89. There is said, Millard, it is not in my favor. Actually, in this case, I want to say that I have purchased the land measuring, I will come to that, Millard. Sell it also, I have an Millard. Measurement of land, Millard, only 175 in length and 7 feet wide. Only, Millard, entry road to my land, Millard, and building.
Balance of convenience was against you.
Yes, held by them. And on another point also, Millard, against me, held by them, Millard. Kindly see that is, Millard, irreparable loss and injury. Page, Millard, 91.
Okay, we will issue notice.
In the meantime, only my friend, is a standing road, Millard. I only one road to go to my residence, and there is one, Millard, one institute also there, Millard. So there is a boundary, and only one thing I want to show your lordship, that finally similar sealed it, by which I have pursued the land, Millard. Page, Millard.
Is there any interlocutory application?
Here, Millard.
No.
No, I have a prayer, interim prayer is here, Millard. And the same petition, yes, that is your, Millard, here.
You are appearing for?
3 and 4, lords.
Still,
3 and 4.
Lordship.
only one line, Millard. Page 63, Millard, kindly see. Particular, Millard. Below, Millard. In assignments, Millard, is I have given translated copy also. প্রকাশ থাকে যে হাতকৃষ্ণ রাষ্ট্রীয় ঘাইপত্তর পড়া নাসিরুদ্দিন আহমেদ, I am Millard Krishna Worship. এই খরিদা জমিনে জোয়া হওয়ার কারণে শ্রীমতী বিমলা জঙ্গিদে মোর উত্তর 1996 নং দলিল, সরি 1196 নং দলিল বিক্রি করা জমির সময়ত উল্লেখ করা 3 ফুট 3.5 ফুট জাস্তার ভাবে দিয়া জমি আর মূল পট্টার সুরেন্দ্র কুমার নাথর মধ্যস্থ তার চুক্তি সাপেক্ষে প্রণতি দেবী জমির পড়া প্রণতি দেবী রাস্তার বাবদ 3.5 ফুট জমি এরি দিয়ে মূলত উক্ত রাস্তাটো 7 ফুট প্রস্থ থাকিব. So that is the only this Millard 7 foot land. And this is where Millard only road to, and also till date Millard it is using, I am using Millard. Only one small vehicle can go, Millard. So my prayer that road may kindly continue till then, let them come, Millard, let them file their reply or Millard. So I have interim prayer in my petition, Millard. And this is, Millard, I have mentioned in my schedule. Schedule A is earlier another deed, Millard, by which I have purchased, Millard, 2 kata land. There is separate, there is no dispute. Only, Millard, schedule B land, but on which, Millard, dispute is going on. And the opposite party, Millard, they have not produced any document that this land is their land, Millard. Anyhow, that will come in the trial stage, Millard. In trial, then we produce. So, I have made a notice may go at this stage, Millard, and only till the pending of this petition, Millard, that interim order may can be stayed.
No, not now. Only after service of notice on the respondents.
Then Milord, road is there. If I am not there causing some disturbance, Milord, so up down is there, Milord. Then will status quo order will be, Milord, then also Your Lordship.
No status quo.
Lordship,
It is
Lordship.
concurrent finding of two
Lordship,
courts
Lordship. And
without,
Lordship.
without hearing the other
No,
side.
they are saying Milord, prime physics case is in my favor. That is I am submitting.
No,
Your
that
Lordship.
is not enough for grant
And
of,
loss is there, Milord. If the road is closed, Milord, today, Milord, supposing, though it is going on, I have passes Patala.
heard Mr. A. Rashid, learned counsel for the petitioner. Also heard, this is a 227 application. So there are limitations. When two courts have held a concurrent view, also heard Mr.
T.R. Gogoi.
T.R. Gogoi appearing for
No,
Respondent
number 3 and 4.
On my submission, Lordship, laws is question is there, laws. If the road is closed, Milord, I may not be able to go to my building, to my house, Milord. And road is existing, till date it is going on, Milord. It is not, it is, I want to open Milord, new road, or Milord, it is closed. Neither it is closed. So my prayer, Lordship, status quo may be granted till date. Till the next date, Milord, if your Lordship find that it is not in use, then your Lordship will vacate. Other than Milord,
where is the order of the trial court?
Trial court order, Milord, kindly see Milord, page 70.
Page
70. 1923, page Milord 70. And trial court's order, Milord, has been vetoed by the learned Milord appellate court. Same dictation,
No.
Milord.
T.R. Gogoi, learned
That is why I
counsel
am
for
some.
respondent number 3 and 4. This application under Article 227 of the Constitution of India.
Page 76.
Read with Section 151 of the Code of Civil Procedure has been filed by the petitioner impugning the order dated 18/9/2024 passed in Miss Appeal number 4/2023 by the Court of Learned Civil Judge Gwalpara, whereby the said court upheld the order dated 1/4/2023 passed in Miss J case number 24/2022 by the Court of Learned Civil Judge Junior Division Gwalpara. Issue notice to the respondents. Since Mr. T.R. Gogoi has appeared for respondent number 3 and 4, no formal notice need to be issued to the said respondent. As regards the respondent number, as regards the other respondents, the applicants, the petitioner shall take steps for issuance of notice upon the said respondent by registered post with AD as well as by usual mode, returnable on 21st of October 2024. Let this matter be listed on the said date. The prayer for interim relief would be considered only after due service of notice on the other respondents.
Lordship.
Only man,
Lord.
that's my prayer. Till then, Milord, status quo order.
No.
Other Milord, if they close my road, Milord, then I will not be able, along with my, there is a institute, Milord.
If they close your road, you come for seeking, this court is there, your case is pending. But your prayer for
road is
injunction was rejected by two courts. So without now one more line.
Then Milord, it will be again Milord, another case, Milord, or I will suffer, Milord. The loss will be to me, Milord. There is a and stress is given
No,
not
no.
till the next date, my lord, so that
After, Sir.
on that day your lordship will hear
Sir,
them.
the
And
concurrent
after hearing
findings,
them, if
lordship.
your lord not satisfied, then you close it
No, lord.
or cancel it, my lord. There is no bar. So my prayer that may you kindly consider, my lord. Otherwise, my lord,
I have already passed on.
Mass of blessings.
Yes, please, lordships. Hello, council on next matter. Matter may be taken after some time.
Order is still remaining item 4.
Lord, they filed an application for vacating the stay, my lord. I'd like to file a reply to this.
Stay or
Stay of the proceedings before the Labor Code in a proceeding under section 11 of the Trade Unions Act.
The registration certificate, I'm representing the
What would-
registrar of trade union. And
who filed the case before the labor court?
yes, because the
Basically-
statutory appeal under section
No,
11
no,
of the trade
before,
union.
before you make submission, what are the facts?
My lord,
Yes, please.
registration of the trade union of the petitioner was cancelled by the registrar of trade union. Against that order of cancellation, an appeal lies under section 11 of the Trade Unions Act, and the appeal lies before the Labor Court. Labor Court is in session of the matter, the appeal is pending. In the meantime, they have filed an application for adducing evidence, which the Labor Court has rejected by order dated 21/2/24. That order is under challenge by this present petition under Article 227 of the Constitution.
On what ground?
On the ground, that is the whole thing. The ground is that the Labor Court has erroneously or illegally rejected the prayer. They are entitled to lead evidence, Labor Court did not. And surprisingly, my lord, this, while passing the interim order, the proceeding has been stayed. That is to that extent fine, but
Which proceedings has been stayed?
my lord, the proceeding,
In,
they were under section 11A. That is the
you are
appeal.
the petitioner.
Yes.
I'm the petitioner.
You are the petitioner.
I'm the petitioner.
On, while issuing notice,
The further proceedings before the tribunal were stayed.
of the appeal,
Of the
before the appellate
of the
forum.
Of the appellate.
And my
That's
lord,
correct.
Appeal is pending before the labor court.
Labor-
Yes.
That, okay.
and my lord, the
That-
original order cancelling the registration has also been stayed in the meantime, which is not the subject matter of the present proceeding. The legality or
Okay,
validity,
okay, let them file
my lord,
written objection.
may present immediately after the vacation, my lord.
Heard, Mr. What is your name?
I'm S. Chakravarti for
Heard, Mr.
the
S.
applicant.
S. Chakravarti. Learned counsel for the applicant. Also heard Mr. B. D. Deka, learned counsel for the opposite party. / petition. Opposite party. Stop. This application has been filed by the applicant for vacating / modifying the interim order dated 26/2/2024 passed by this court in CRPIO number 83 of 2024, whereby the further proceedings of Miss Appeal number 1/2023 as well as order dated 30/8/2023 passed by the Registrar of Trade Union cancelling the registration of the opposite party was stayed. Learned counsel for the opposite party praised for some time for filing a written objection against the prayer for vacation of the interim order filed by the applicant. The prayer is allowed. Let this, you are appearing for?
Lordship, in this matter, order dated 26/2/2024, name of the government advocate as P. K. Pukon was recorded. But we are not in party in this matter. Lordship, we have taken instruction from the concerned authority and this may be put in record, Lordship. Name of the KF Ukon should be struck from this Lordship.
Miss K. Fukun,
Lordship.
only Miss K. Fukun.
Only Miss KF Ukon, Lordship, order dated 26/2/2024. It was
Okay.
recorded as government advocate, Lordship.
Okay.
It should be struck out, Lordship.
Let this interlocutory application be. Let this case be listed again when? After
25th of October, my lord.
on 25th of October. Stop. In main case, heard Mr. P.D. Dekar, learned counsel for the petitioner, also heard Mr. S. Chakraborty, learned counsel appearing for the sole respondent. Mr. T.R. Gogoi, learned government advocate, makes a submission that in order dated 26/2/2024, this court had directed the registry to reflect the name of government advocate in the cause list. However, he has informed that the government is not a party in this case, and no instruction is there for the government advocate to appear in this case. And therefore, he prays that name of Ms. K. Fukon should not be reflected in the cause list henceforth. The prayer is allowed. Registry shall not reflect the name of Ms. K. Fukon, government advocate Assam, as counsel for the respondent in this case in the cause list henceforth. List this matter again on 25th of October.
Interim to continue.
The interim order shall continue till next day.
Till then.
Obliged.
Lordship, this matter may be fixed for hearing, Lordship.
Why it is fixed today? Or LCR record, I say. Heard Mr. G. Imtiaz.
Yes, ma'am.
Learned counsel for the appellant. Also heard Ms. M. Dekar, learned counsel appearing for the sole respondent.
1 and 2.
How many respondents are there? Appearing for the respondents.
Lordship, 2.
Who is appearing for one?
Lordship, 2 respondents. We
They
are
are appearing for both,
Yes, Lordship.
for both the respondents. The records of title appeal number 2/2021 as well as title suit number 20/2014, which were requisitioned in connection with this appeal, has already been received by the registry. This appeal is therefore ready for hearing. Let this appeal be listed for hearing in its due course.
The date may be fixed. Highly obliged.
Deeply obliged.
Yes, arbitration.
My lord, these records have come, my lord. So matter will fix for hearing. We both agree in the first week of December, my lord.
First week of
December.
heard Mr. J. Roy, learned senior counsel assisted by Miss S.S. Roy. Who is assisting?
My lord.
Assisted by Miss S.R. Gogoi, learned counsel for the appellant. Also heard Mr. B.D. Dekar, learned counsel for the respondents. The records records of the trial court have been received, and this appeal is ready for hearing. Let this matter be listed for hearing.
Third, third of December.
Oh, fixed date.
Or maybe first week of December, my lord. Or second week of December. Second week of December.
In the second week of December on a date to be fixed by registry.
Yes. Oblige.
Obliged.
If this notice has been issued and the sole respondent had entered appearance lordship. Thanks for petition lordship.
Heard Mr. R. Fukon, learned counsel for the petitioner, also heard Mr.
And Borwa lordship.
N. Borua, learned counsel for the sole respondent.
Yes, sir.
The records would not be necessary. No, we can fix it for admission hearing.
But for that only thing is that there is an observation maybe from in lordship to state the further proceeding lordship. After service of notice having the respondent lordship.
What is your submission?
Mostly, entire matter is fixed. All our matter is pending in Udalguri lordship. So, mainly,
And this prayer for transfer is from
Dalguri to family court, Tamil Metro lordship.
I will file objection lordship.
against the interim.
Yes, lordship.
Let them file objection. At what stage this divorce suit is pending?
Evidence.
What is the next date?
Next day, 11th of November.
I will file objection. lordship.
11, we will fix it before that date. Learned counsel for the respondent prays for some time for filing written objection. The prayer is allowed. Let this case be listed in first week of November on a date to be fixed by registry.
Obliged. If may one thing, let's say, an observation may be given that after their filing of the objection, intent will be considered.
We will dispose of the
Lots. Obliged.
May I please, the lordship? The lordship, this IA is for the release of the deposited amount. The lordship, 50% of the awarded amount was deposited by the insurance company.
how much?
50%.
Any objection
Lordship, we need some time to file our objection, your lordship.
against this
Yes, your
application?
lordship.
Your lordship,
Yes.
they have received the copy of this application on 22/2024. And they have also sought for adjournment on last occasion also. So they could have filed.
How much time you require?
Lordship, immediately after vacation, your lordship, on 21st October, it may be listed.
Heard Mr. D. Mondal, learned counsel for the applicant, also Ms. F. N. Zaman, learned counsel for the respondent / insurance company, who prays for some more time for filing written objection against the application filed by the petitioner. The prayer is allowed. Let this case be listed on 24th of October 2020.
Oblige, your lordship.
Highly obliged.
Your lordship, I am the applicant in IA 120/24. I filed the application for release of the amount deposited by the insurance company.
Any objection?
Lordship, only that lordship, we have taken one ground that deal was fake lordship. And therefore lordship may be release, furnishing an indemnity bond lordship.
You furnish indemnity bond. Heard Mr. S. R. Gogoi, learned counsel for the applicant, also heard Ms. M. Chaudhary, learned counsel for the opposite party / insurance company, This interlocutory application has been filed by the applicant slash claimant, praying for directing the registry to release the amount of rupees 2,50,000 that is 50% of the awarded amount. Okay,
No lordship,
not 50%.
not 50%. Amount is, amount, subject to amount of 2,50,000.
Okay, 2,50,000, which was deposited by the appellant before the registry of this court in pursuant to the order dated 21/8/2023, passed in IA number 2393/2023 in connection with MSC case number 327/2023. Learned counsel for the opposite party, insurance company, has submitted that she does not have any objection provided the applicant furnishes an indemnity bond to the extent of the amount which has been deposited by the applicant. Stop. Considering the submissions made by learned counsel for the parties, the prayer is allowed. The registry is directed to release the deposited amount of rupees 2,50,000 to the who is the applicant?
We are going to the claimant, applicant, Dharmendra Chaudhary, alias Bablu.
To the applicant slash claimant Dharmendra Chaudhary alias Bablu on his furnishing an indemnity bond to the extent of rupees 2,50,000, after proper verification. This interlocutory application is accordingly disposed of.
Lordship, so far as appeal is concerned, Lordship, we have filed an affidavit, Lordship, regarding service of dusty service, Lordship, upon respond number 2 and 3. Service is complete, Lordship. They have served, they have received the notice.
Mr. S.R. Gogoi, learned counsel for the appellant, also Ms. M. Chaudhary, learned counsel for the respondent number 1. No, sorry.
No, I am for the appellant, Lordship. In
Appeal-
appeal memo, Lordship. In appeal, Lordship.
Heard Ms. M. Chaudhary, learned counsel for the appellant, also heard Mr. S.R. Gogoi, appealing for respondent number 1. Learned counsel for the appellant has submitted that the notices on respondent number 2 and 3 have been duly served through dusty mode, and to that effect, an affidavit of compliance has also been filed by the appellant. I have stopped. I have perused the said affidavit, which is wherein the notice to respondent number, wherein the copies of notice to respondent number 2 and 3 have also been annexed. And on those copies, the signatures of respondent number 2 and 3 are appended. Stop. In view of above, the notices issued to respondent number 2 and 3 are held to be duly served. The service on the parties is complete. The records of the
Already received, Lordship. Lot of record has already received.
records of MSC, concerned MSC case has already been received by the registry, and this case is ready for hearing.
Lordship.
Let this matter be listed for hearing in its due course.
Must oblige.
1204 disposed of.
May I please, Lordship, I am for the respondent lordship. This I is there, I is for confirmation of delay, but petitioner advocate is not there. Appellant.
None has appeared for the applicant on call. Miss, what is your name?
S.E. Ahmed.
Miss S.E. Ahmed. Learned counsel for the respondent number or sole respondent.
Sole respondent.
Respondent is present. We'll fix it after puja. vacation.
Here in this matter, Lordship, this appeal is challenged against the judgment and order passed by the district judge for guardian and work of 3/10/23. And in the same regard, again, a case is pending in the family court, before the family court. Two cases are there
Okay.
for the same reason.
No, but we are now concerned with
This
condonation of delay only.
delay, yes, Lordship. They are
Because
also-
appeal is not yet admitted. So we'll see whether the applicant comes or not.
Yes,
Otherwise, we'll dispose it off on next day. Let this matter be listed again on 22nd October 2024.
Lordship. Lordship. Mm.
But here, my lord, we have filed, my lord, substitution petition and sitting aside substitution and also condonation, my lord. So since, my lord, there is a condonation petition, my lord, so let, my lord, notice go to the court.
Abatement, when the appeal was abated, who died?
My lord, respondent number, appellant number 2 and 4 died. And respondent number 3 died.
So this is for
And so far, my lord, respondent number, appellant number 2 is concerned, my lord. Appellant number 2 is the mother of all, my lord, the appellants, and therefore all other already substituted.
And
So
four?
therefore, we have not filed any
for.
for respondent number 2, appellant number 2.
So
Appellant number 2 is the
substitution is
mother.
not required.
Not required.
And appellant number 4,
4 and, my lord, for 4, my lord, we have filed. And also for, my lord, respondent number 3, we have filed.
you have to file separate applications.
My lord, both are barred by limitation.
Abatement is also barred by limitation.
My both.
Then you have to file an application for setting aside abatement or.
My lord, we have filed. We have filed, my lord, since, my lord, the long delay is there and therefore we have filed a condonation petition. So at this stage, my lord, may I pray, let notice go, my lord.
No, this limitation, condonation of delay, you have filed for condoning delay in filing substitution petition.
My lord,
Substitution petition.
my lord.
But when respondent number 3 died? When he died?
My lord, my lord, he has also, my lord, died. No date is given to us. But when in last occasion, when the matter was listed.
Okay, we are
before
issuing,
reasonable-
we are issuing notice. Heard Mr. M.H. Chaudhary, learned senior counsel assisted by Mr.
S.N. Ahmed.
S.N. Ahmed, learned counsel for the applicant. This application under section 5 of the Limitation Act, 1963 has been filed for condoning the delay. Delay of how many days? You have condoning the delay in filing substitution petition on or substituting the legal heirs of appellant number 4 and respondent number 3 on the death of, on their death. Stop. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by registered post with ID as well as by usual mode within 7 days from the date of this order, returnable on 14th of November 2000.
Highly opposed.
Was it 14 days delay in filing appeal?
14 days delay. But still there is a delay. Notice will go.
Notice to come.
Heard Mr. S.K. Goswami, learned counsel for the applicant. This application under section 5 of the Limitation Act, 1963 has been filed by the applicant for condoning the delay of 14 days in preparing the connected appeal. Stop. Issue notice to the opposite parties.
Proceed by usual process, then better process. Usual process immediately start by court process.
Issue notice to the opposite parties through usual mode. The applicant shall take steps for issuance of notice within 7 days of the date of this order, returnable on 13th of November, list accordingly.
Steps by usual process. Apply.
Where is the water? Yeah, same, my lord. And the appellant, I was saying, it has been admitted, my lord.
Appeal is admitted.
Yes, yes. The thing is, this is respondent number 9, my lord. Expired. That is expired on 26/3/2019. We are not aware actually, respondent number 9. Only on 7/11/2023, we are informed
Aru kekhon keta se aaye.
there are 4 IA, my lord.
First, you have to condone the delay for setting aside abatement.
Abatement, yes, yes.
Which one is that?
Yes, yes, that is my lord. That is my lord, IA 2027, my lord. That is under application under order 22 rule 9 of the CPC for setting aside abatement. And there is a delay of, our calculation was 1800, but the filing there registry there calculated is 1148. 1148 days by. In setting aside abatement also.
No, for that, you have to file an application for condoning that.
Yes, yes, that is 2025.
20?
2025.
Okay, notice will go. Heard Mr. Notice will go to other side. Heard Mr. A.U. Chaudhary, learned counsel for the applicant. This application under section 5 of the Limitation Act has been filed by the applicants / appellants for condoning the delay of 1148 days in filing an application for setting aside abatement on abatement of appeal on death of
Respondent number 9, my lord.
respondent number 9.
That is,
Stop. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 14th of November 2020.
there is substitution for.
Later on,
come.
later on. Today only this much.
My lord.
List accordingly.
Obliged.
2025 होते हैं order होगा बाकी मिला करेंगे.
If I may, my lord, my deepest apologies, my lord. In item 25, there's an interim. My lord. That may be.
Item 25 होत one more interim shall continue.
Deeply obliged.
Item 47. I have this motion. In this case also, what is respondent number 1 expired. So we have filed the applications first. 2472 may be taken up first.
2472.
72. This is an application under section 5 for condoning delay of 725 days in filing the application for setting aside abatement. We were ignorant about the depth of this. That's point
22
number one.
4 plus 5. No, you have not filed application for setting aside abatement.
I filed.
No,
I filed.
this is for condoning delay.
Delay, then lordship, 2473 is the setting aside abatement. And 2470 is my substitution. Three applications I have filed. 2470.
Abatement application.
Sorry, 2470. 2470.
You quoted wrong. You have quoted wrong provision.
9.
In both the, for setting aside abatement, what provision you have mentioned? It has to
4-5.
be
22 rule 4-5.
22 rule 4-5 is for substitution. It has to be 22-9.
9 lordship, it is, but 9 is for the plaintiffs, dismissal, abatement and dismissal.
No, effect
Rule
of
2, the
abatement.
plaintiff or the person claiming the legal of a deceased plaintiff or the assignee or receiver in the case or an insolvent plaintiff may apply for an order to.
You are the appellant.
Here respondent died, lordship. Appellant has not died. Plaintiff includes appellant as per order 22 rule 11. And respondent is defendant.
No, it has to be under 9. When suit is abated, abatement is on death of the defendant against that defendant. Here, in your case, who died? Defendant number?
1. Respondent
You-
number 1.
Respondent number 1 died. So if within 90 days, no substitution is made,
Is abated.
the appeal would be abated. And the consequence will follow in order 22 rule 9. So
Anyway,
you
for
have-
lordship, wrong provision, it will not be fatal.
it is not fatal, I am just mentioning, it has to be rectified. You may rectify the cost item. You verify the appropriate whether Rule 9(2), you have to file an application under order 22, rule 9 clause 2. We'll take it up as next item. You verify which is the appropriate provision. And if it is the appropriate provision which you have mentioned, you have to make me understand that this is the appropriate provision.
Yes.
Why rule 9(5), rule order 22, rule 9,
Rule 9 says it's plaintiff, always plaintiff, for plaintiff.
you read it again. And then make me understand.
Lordship.
We'll call as next item. Or after a short break, we will take it up again. This application under Section 5 of the Limitation Act, comma 1963 has been filed for condoning the delay of 725 days in preferring an application for setting aside abatement in this on death of respondent number 1. Stop. Issue notice to the opposite parties.
Opposite party number 1A.
Since Mr. D. Borgohain
B. Borgohain.
B. Borgohain is appearing for this opposite party number 2 and 3, no formal notice need to be sent to them. As regards opposite party number 1, the applicant shall take steps for issuance of notice by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 18th of November. Okay.
Not license.
Please, Your Lordship. Your Lordship, this is an application for refund of the statutory deposit of rupees 25,000. Your Lordship, that we had deposited at the time of filing of the MSC.
Case has been disposed of.
Yes, Your Lordship. The
Heard
case has
Miss-
settled on compromise.
Heard Ms. P. Borthakur, Learned Counsel for the applicant insurance company. This application has been filed by the applicant for praying for refund of the statutory deposit of rupees 25,000 made by the applicant as appellant while in MSC appeal number 43/2022. Stop. Learned Counsel for the applicant has submitted that the said appeal has been disposed of on
7/2/2024, Your Lordship.
7/2/2024. Stop. Considering the fact that the appeal filed by the appellant has been disposed of, comma, the registry is directed to refund the statutory deposit of rupees 25,000 made by the applicant in MSC appeal number 43/2022 after proper verification. This interlocutory application is accordingly disposed of.
Okay.
What is this, IA is for subscription of respondent number 1, who expired on 17/6/2024.
You are appearing for?
Respondent 1 option.
Who are the sole respondents? No.
Lordship.
How many respondents were there?
5, we are sons of respondent number 1.
Heard Mr.
I Hassan.
I. Hassan, Learned Counsel for the applicant/appellant. Also heard Mr.
Lordship, AK Das on behalf of M. Khan.
A.K. Das appearing on behalf of M. Khan, Learned Counsel for respondent number 1.
Yes.
This application under Order 22, Rule 4 of the Code of Civil Procedure has been filed by the
Appellant.
Who are these 5?
They are the sons of respondent number 1.
Abu Tahir Ali by the applicants. No, who are the petitioner in this case?
The appellant is the petitioner, Lordship.
Who is the appellant?
This Abu Tahir Ali, Ilyas Ali, Yasin Ali, Nur Islam, Nur Hussain. Ilyas Ali is one of the applicant here, representing the other applicant.
By the applicants for substituting the legal heirs of respondent number 1 who had passed away during the pendency of the connected second appeal, that is regular second appeal number 245/2018 on 17/6/2024. You have no objection.
This file within the limited. Yes, Lord, I have
It is supported by an affidavit.
I have objection, Lord. I have filed the objection, Lord.
What objection? The substitution petition has been filed within the period of limitation. Whether they are not the legal heirs, that may be the objection. Okay, let them file objection. You take instructions, you may take instructions. We will. You take instruction, we'll take it up after in the second half. If you don't have an objection, we will allow this.
Yes, sir.
Let him take instructions. He is appearing on behalf of some other counsel. Will in the second half, we'll take it up again. If he concedes, we will allow this petition. Otherwise, we will fix a date. Let him come up.
Lordship.
Item 41 and 42.
Yes. Please, your Lordship. Lordship, FAO was filed in the connect, but there is a delay of 54 days, so a section 5 application was filed. And on 14/8/24, the Honorable Court had directed us to take steps upon the respondents. But as per the office note dated 21/9/24, the steps could not be completed due to the notice form which was not included. So some defect is there in the steps, so we'll rectify it and maybe listed after vacation.
No, what is this?
Some notice form is missing from the steps, so the steps could not be communicated.
In the IA 2408.
2408/24.
2408. Heard Mr. G. Kaushik, learned counsel for the applicant, who prays for some more time to take steps for issuance of notice on the respondent in person to the, not respondent, opposite parties, in person to the direction of this court by order dated 14/8/2024. Stop. The prayer is allowed. The petitioner shall take steps within 4 days from the date of this order. The notices shall be returnable on 28 October 2024. List accordingly.
Publish.
May I please, your Lordship? Lordship, this application is for substitution. Lordship, the applicant died on 21/05/2024, Lordship. Lordship, may kindly come to the para 1, Lordship.
No, is it within the period of limitation?
Lordship.
Within 90 days?
Lordship.
Okay. How many respondents were there? Who died?
Lordship, the appellant number one died.
How many appellants were there?
Five appellant.
In RSA, whether notices are issued?
Lordship. Service complete and LCR received.
Yes. Who, whom you want to substitute?
Appellant number one.
No, who are the heirs, legal?
They are the legal head, son of appellant number one, Lordship. Pangsi Das Ravi, Pangsi Ravi Das.
Will issue
Legal heirs
notice.
and legal.
Will issue notice.
Lordship, I'm for the appellant, Lordship.
Okay, it is within the period of.
Within the
limitation.
period.
Heard Mr.
N. Brahma, Lordship.
N. Brahma, learned counsel for the applicant. This application has been filed by the applicants. How many appellants were there?
Five appellants.
Filed by the applicants who are the legal heirs of appellant number one. Praying for substituting their names in place of appellant number one. Stop. On death, stop. Appellant number one, comma, on his death. Stop. It is submitted by learned counsel for the appellants, applicant that the appellants have, appellant number one has expired, has passed away on 21/5/2024 during the pendency of the connected regular second appeal. It is also submitted that the prayer for substitution has been made within the period of limitation. However, we are issuing notice. They may oppose regarding your relationship.
Also, they are the sons of Bansi Rambavi.
Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 4 days from the date of this order, returnable on 4th of November. Let this matter be listed accordingly on 4th of November.
Trustee, I have no objection also.
Yes, in the last line. One side, stop. Learned counsel for the applicant has submitted that the legal heirs of the respondent number one, late Husainara Begum. No, the names of the legal heirs of respondent number one, late Husainara Begum, have been mentioned in paragraph number 2 of the application. It is submitted that all of them are the sons of late Husainara Begum. And he prays for allowing the said legal heirs to be substituted in place of respondent number one. Learned counsel for the applicant, learned counsel for respondent does not opposes the prayer of the petitioner, hence the prayer is allowed. The registry to substitute name of following legal heirs, named dash Rajiv Islam, number one, Sajid Islam, Zabed Islam, Ghalib Islam, and Yasir Islam, as respondent number one within bracket Roman 1 to respondent number 1 within bracket Roman 5 in place of deceased respondent number 1 in the memo of appeal. And thereafter list the connected RSA or list the connected RSA after puja vacation on a date to be fixed by registry. Stop. This interlocutory application is accordingly disposed of.
Lordship, in this case, as per last order, I have been directed to take steps on the legal heirs. So this is respondent number 5. Now, what we have came to know that before filing of this appeal, respondent number 5, in the original suit, he was the one of the plaintiffs. He died before filing of the appeal. So we have filed an application for implement of the legal heirs. Order 1, Rule 10(2) of the legal heirs.
No, implement, if the respondent has died, the prayer has to be for substitution only.
It at the time of pendency of title appeal, Your Lordship, the person concerned died.
Thereafter,
He was not substituted at that time.
therefore, you have not made With
Yes, that's why
them
I
as
have,
party.
petition I have taken actually.
Okay.
Your Lordship, in the implement petition, they have not mentioned the date of death, Your Lordship.
That we do not know. We have only came to know the month, Your Lordship.
Okay, you file objection, you have objection.
I'm just
We
mentioning
have
it.
tried of a level, but could not get the date, Your Lordship.
How many respondents are there
How many respondents in the
in the appeal?
Yes. 5.
11.
11 respondents are there. All are served except 5.
Why 5 is not served?
He expired.
You have
He
made
returned
5.
back.
You have made 5 as a party in the appeal.
Yes, Your Lord.
Then you have to file substitution petition, not implement. Because his respondent number 5 has been made party in the appeal, in the second appeal. Later on, you came to know that he had actually expired even before you filed
the
the
title appeal.
titles appeal.
During the pendency of title. appeal.
So the predecessor in interest of the present applicants is already a party in the RSA. Respondent number 5 is a party,
Yes, Your Lordship.
though you came to know that he died even before filing of the appeal.
This appeal, Your Lordship.
Then the application has to be substitution application. Because whom you want to implement, the legal heirs.
Respondent number 5. Page number 6, Your Lordship. Wife and one daughter.
No, in IA, whom you want to implement, wife and daughter.
Page number 6, Your Lordship.
Yes.
Legal heirs, one daughter. Two daughters are there, Your Lordship. Sorry. Legal heirs of respondent number 5, deceased.
Because respondent number 5 is already on record. His name is on record.
Actually, what as per-
Rightly or wrongly, it is on record. Later on, you came to know that he had expired even before filing of.
They have already submitted on the last occasion.
Yes. Heard Mr.
Ebora,
Aburwa, learned counsel for the
petitioners.
petitioner, who none has appeared for the respondent side. Learned counsel for the petitioner has submitted the gist of written argument as directed by this court by the earlier order. The hearing is concluded, judgment reserved. Judgment reserved. Yeah, Duta written argument signed. Check করি। Twenty.
2021.
Yes.
May please your lordship. It's reported 39 application lordship. Well, now it's 483. Then the petitioner was arrested on 19/2/2022. Today is about 2 years, 7 months, 15 days lordship. 11 days lordship. 954 days.
Okay.
So lordship, thereafter, charge sheet, final complaint filed, lordship on 16/8/2022. Then my lord, charge was framed on 4/4/2023.
Panel complaint on
16/8/2022.
Okay.
Thereafter, lordship, charge frame 4/4/2023.
How
In a
many?
final complaint, lordship, human number 13 numbers, no? 14 numbers, total 17 numbers of witnesses cited along with the final complaint, lordship. And out of that, during this period, lordship, 7 witnesses examined.
Yes.
So, my lord, in this case, in the final complaint, they have alleged that 2 vehicles, their information was that 2 vehicles.
Where is the complaint?
Complaint is at, it start from page number 26 and relevant portion is at page number 27. Lordship got it. Page number 27. So lordship, as per the paragraph number 1 on 18/2/2022, see Anil Kuswa received an information that 2 vehicles were supposed to arrive at Toll Plaza, Nazira Khat, lordship. at around in between 18 hours to 22 hours in the evening. That vehicle number also mentioned, one Maruti Swift Desire and then Maruti Gypsy. So Lordship, thereafter team was formed and then they moved to the Nazira Khat toll plaza at Sonapur, Lordship. Thereafter, what happened, Lordship, that the team formed 11 numbers of team members were there in 2 vehicles. Thereafter, they intercepted first Swift Desire bearing number AS03H3191. They found the vehicle first at the collection point at Toll Plaza, Lordship, the Swift Desire. But just at the Toll Plaza collection point, where Lordship is aware about these things, that CCTV footage always available at that point, Lordship. But Lordship, what happened? This vehicle was not intercepted just after getting the vehicle. They waited for some moment so that some other vehicle will come, and then so that from there they collect the contraband, because there was no contraband. That was the contention of the petitioner. In the trial court also that plea has been taken.
No
So,
contraband in the Swift Desire.
Desire, because that is why they waited this vehicle for a moment, and thereafter
Who waited?
by the intercepting team, because therefore they did not intercept the Swift Desire also. Then what happened, Lordship? Subsequently, this Maruti Gypsy arrived at the same toll plaza collection point. Then that vehicle was intercepted in the page number 29. Lordship will get that this point will clear after perusing this, Lordship. Paragraph number 2.
Yes.
May I read, Lordship?
Yes. Page 29.
29, second paragraph, Lordship.
That is para 5.
It's continuation of para 5. Yes, continuation of para 5, paragraph number 2, because these are lengthy. That is why, Lordship. If Lordship want to read, then we can read from the first of this paragraph, Lordship. Para 5, Lordship.
Yes.
That thereafter, the 2 persons from the toll plaza as independent witnesses that they have collected. Then, Lordship, paragraph number 5. Thereafter, NCB team along with 2 independent witnesses started surveillance in that area. On dated 18/2/2022 at around 18 hours, a Maruti Swift Desire bearing number so was seen coming from Sonapur side towards Guwahati. As the number of Swift Desire was according to the information, this vehicle was stopped at collection point of Toll Plaza. There were 2 persons seated inside the Swift Desire car. Anil Kushwaha introduced himself, his NCB Guwahati team members and 2 independent witnesses, and told them the information available with the team that they were trafficking morphine, and asked them to introduce themselves. Driver of the Swift Desire car introduced himself as Atar Rahman or alias Atar Rahman. Then address.
Who is the petitioner in this case?
In this case, Atar is the petitioner. In the second case, some as other co-driver, as per the final complaint, he is the petitioner also. Allegation is same, Lordship. Then after co-driver introduced himself as Suhud Ahmed Laskar. After few minutes, a Maruti Gypsy so and so was seen coming from Sonapur side. It was also stopped at Nazira Khat Toll Plaza. There was only 1 person seated in this Gypsy car. See, Anil Kushwaha introduced himself, his NCB Guwahati team members and 2 independent witnesses, and also told them the information available with the team that he is trafficking morphine, and asked him to introduce himself. Driver of Maruti Gypsy so and so introduced himself as Akram Hussain Chaudhary. He is not before you, Lordship. Sri Anil Kushwaha told them that they will search the Maruti Swift Desire bearing number so and so and Maruti Gypsy, and requested to cooperate the search operation. Before initiating search, Sri Anil Kushwaha offered them search of his team, to which both of them denied. At around 18:30 hours, search of Maruti Gypsy bearing number so and so was started. Maruti Gypsy first search, Lordship. But As per their information, they first stopped the vehicle, Maruti Swift Dzire. They did not charge that. While charging the Gypsy and after removing the nuts and bolts of seat belt plates, which are located behind the seat of driver and co-driver, it was found a special made cavity in the body, right and left sides of front seat of the Gypsy. So, and so when it was thoroughly searched, the said cavity, it was seen some transparent plastic packets kept there where kept therein where light brown color powdery substance were concealed. One by one, these packets were taken out. 7 packets recovered from the driver's side and 7 packets recovered from co-driver's side. From all these transparent plastic packets containing brown color powder, small quantity of this powder from all 14 packets were tested with the drug detection kit available with the team. These gave positive test for morphine. Thereafter, search of Maruti Swift Dzire car bearing registration number so and so was started. While charging the Swift Dzire, 6 and 4 transparent plastic packets containing brown color powder were found under the seat of driver and co-driver respectively. Thereafter, all the formalities observed, Lordship. From all of these transparent plastic packets containing brown color powder, small quantity of this powder from all 10 packets were tested with the drug detection kits available with the team. These gave positive test for morphine. Thereafter, all packets of morphine recovered from cavity after removing of nut and bolts of plates behind the seats of driver and co-driver of Maruti Gypsy. So given these are the marking given in these 2 paragraphs. These formalities observed, Lordship. Thereafter, they waited and these things found that total, Lordship, total weight was 12.040 kg recovered from both the vehicles as per this final complaint. And thereafter, 7 witnesses examined by the prosecution. These are PW1 is their departmental witness Santanu Guha, and then PW2 is FSL, 3 is Mahesh Prasad, 4 is Mahesh Prasad, one of the team member and their officer Lordship, 4 is Tinku Thapa is driver, 5 is Jugal Chandra Das, he also driver, 6 is one of the intelligence officer Shakil Ansari, 7 is Pankaj Kumar Sohan. But in their deposition, they have clearly stated that this Maruti Gypsy found first. Thereafter, they kept aside the vehicle and then the second vehicle came and then they intercepted first the second vehicle. And from the second vehicle, nuts and bolts were there. That was open, and from there they brought all the contrabands. And our contention is that nothing was in our vehicle, Lordship. That is why my vehicle was not intercepted first, Lordship. That is the first contention of this petition, Lordship. And in this case, 17 numbers of witnesses cited in the final complaint, along with the final complaint, Lordship. But out of 17, within this 2.5 years, only 10 more than 2.5 years, Lordship, 2 years, 7 months, 11 days, 954 days. Only 7 numbers of witnesses examined, Lordship. So there is, though they have filed the objection, Lordship. They have filed the objection, Lordship. In the objection, they brought the allegation that PIT NDPS was imposed upon the accused petitioners. In that case, Lordship, my reply is that though we have not filed.
What they have stated in the objection?
In their objection, they have stated one ground, Lordship, that these persons, the PIT NDPS was imposed upon these persons, Lordship.
Preventive detention.
Lordship. In that case, Lordship passed an order, Lordship. In division, we challenge that petition, Lordship. Lordship order is there. That was not rejected. But though they have mentioned that it was rejected, it is in In their objection, Lordship, my reply to that regard is that Lordship, kindly go through that order.
Where is the order?
Order is with their. Okay. Also page number. Or. My lord will find it in page number 86 of the page number 85, Lordship. In item number 21. This was Lordship order in division bench. It was passed in court number 3, Lordship. This was closed as because
Page number?
page number 85, relevant portion will be found at Lordship.
85 is the judgment of Supreme Court.
No. In the objection, Lordship.
Yes, in the objection.
First and next order.
85 is something else.
In item number 21, Lordship, 20, na?
We are taking up item number 20,
20, 21.
not 21.
20, it was not annexed. In 21, it was annexed, Lordship. Same matter, that is why I am mentioning this. It is করেছে
ওটাতে করা আছে
এটা করা নাই নাকি নাই করা নাই করা না হেরি কইছে annex করা
in one case it is
হ্যাঁ কইছে annex করা না
bail application 229
yes bail application 229 it was annexed in page number 85, Lordship. Lordship will find the relevant person at page number 87. On that day, one of my junior colleague, Lordship, she has mentioned that this matter was admitted after expiry of the date. What was within the period stipulated as per the PIT and DPS, Lordship, this must have to complete it. But because of non-filing of affidavit and all, this matter could not taken up by the court. That is
1 year period got lapsed.
yes, Lordship. Even after that affidavit filed and division bench, Lordship, already before taking up your Lordship, this was admitted for hearing. On that day, Lordship, because it was the matter is in fact was because of lapse of time, that is why it was closed. It was not rejected, Lordship. But we have the copy of that PIT and DPS, Lordship. PIT and DPS was wrongly imposed upon the accused person, not within the stipulated time. That part we could not argue before the court, Lordship, because the matter has been closed. There are some because there is some time period in PIT and DPS when it is imposed upon a person, Lordship. So that was closed, Lordship. That was not rejected. So right now that period over. And the person inside the jail for about 2 years, 7 months, 11 days. That is why, Lordship, NDPS Act and our Constitution, Lordship, I would like to place to that regard. Lordship, Article 36, Section 36(1). Section 36(1), the government may, for the purpose of providing speedy trial of the offences under this act by notification in the Gazette, official Gazette, constitute as many special court as may be necessary for the such area or areas as may be specified in the notification. So, Lordship, in this case, for the purpose of speedy trial, this case is registered under the special act. That is why special court needs to take speedy trial, Lordship. In this case, already more than 2.5 years completed by the accused person, Lordship. So in this case, they could not complete the trial within 2 years, Lordship, within 2.5, more than 2.5 years, Lordship. Then Constitution also guaranteed Article 21, Lordship, which is discussed in so many cases, Lordship. We will place that thing, Lordship. The allegation is that these persons were earlier convicted, and that is why their conduct is not believable. But Lordship, my contention to that regard is that in this case, as they
were earlier convicted
Lordship,
in NDPS case.
NDPS case, Lordship. That is why Pete NDPS was there. And Lordship, my contention is that is why they were implicated in this case, Lordship. Because nothing has been recovered from the person, Lordship. Because of that reason, they wanted to drag the person in this case, Lordship. That is why, Lordship, in this case, Lordship, what happened? They implanted this contrabands in their that vehicle, Lordship. That contention we have taken. We retracted the confession, our statement also before the court, before the authority, Lordship. It is in the record.
Where they implanted?
Lordship?
Where have they implanted? Because the seizure was made at toll gate.
Yes.
Where there were CCTV cameras.
Yes.
If it was implanted, it would come in CCTV.
Lordship, that is why we filed a petition before the authority, before the trial court, Lordship, on the first day to keep the CCTV record, to preserve the CCTV record of the toll gate, Lordship, and to inform the investigating authority, to show my innocence in this case.
Okay, otherwise that is your plea that it was implanted.
Yes,
And at this stage, it is a plea only.
Yes, that is my plea, and I can establish that plea through the deposition of the witnesses, Lordship, because witnesses at no point of time stated that there are 10 to 12% in the team.
Okay. Otherwise, your ground is of prolonged incarceration.
No incarceration.
But what will happen if you were convicted for NDPS offences earlier also? Whether same treatment can be?
My lord, that is why, Lordship, my contention is that Article 21, this case is not still established, Lordship. This case is still today not established. It is under trial.
It is under trial.
Trial.
But you were once convicted.
That is why this allegation they brought, Lordship. They were after me, Lordship. They wanted to drag me in any NDPS cases in this way they arrested my lord.
But you were found in, this is Suhud Ali.
Suhud Ali Laskar.
Suhud Ali Laskar was found in the vehicle.
Suhud Ali Laskar and me, we were traveling in the both were traveling in
your
same.
Your name is Ataur.
My name is Ataur.
Ataur is item number 21. We are now taking up 20.
20
is Suhud Ali.
Suhud.
You were
Suhud Ahmed Laskar.
You were
driving. Both the persons convicted in some other cases.
No, you were driving Desire or Gypsy?
We are driving Desire. We are in Suhud and Ataur in Desire.
Desire.
Yes.
Now, whether there was recovery from Swift Desire?
Swift Desire from the Lordship, both the side of drivers, Lordship. Driver and pro drivers.
Then there is recovery.
But recovery is regarding that, Lordship. My contention is that why they have not intercepted the vehicle first, Lordship. If there are 13 to 14 persons were available, one team can recover my vehicle and they can wait for the other vehicle.
What was the time gap?
Lordship, time gap is not mentioned in this final complaint, Lordship.
No, if the time gap is less, because they had prior information that 2 vehicles will be coming.
That is well,
Therefore,
and that is the restricted area. Nobody can evade these things, Lordship. If once the bar down, then nobody can pass that thing, Lordship. So there was no question to afraid that they can fly away from them because they have no information that these persons are waiting from them. That is why lordship, that is the restricted area. Once person entered, even lordship cannot pass that area. So that is why lordship, they
No,
could.
but on record, materials are there
My lord, the material,
showing that recovery was made from your vehicle also.
my vehicle also. But lordship, as per the deposition, what we found, that points we have brought during the trial, this vehicle was waited and subsequently that vehicle came and from their vehicle first intercepted. If anything was there, first my vehicle found. If my vehicle found.
No, what was the time gap? The time gap is important.
Time gap, nowhere mentioned,
No,
lordship.
but you know the time gap if your vehicle is checked later on. Suppose the time gap is 2 minutes only. They can wait for second vehicle.
No, lordship, they have one person's deposition is there. After about half an hour, that vehicle came.
Okay.
So in that case, lordship, my contention is that once lordship, if believe or grant the bail to the accused person, they can establish their case beyond reasonable doubt during the trial, lordship. And
So
then
your main plea is that
they are inside the jail for about more than 2.5 years.
long incarceration.
Long incarceration. And
Any other submission
submission regarding
that the contraband was recovered from your vehicle?
that is the allegation.
You are not denying.
We are denying.
You are saying it is implanted from Maruti
Yes.
Gypsy.
That is why we filed a petition before the trial court just after initiated this case, lordship, to keep the recording of the toll plaza of that during that period, lordship.
Okay.
Because we are innocent, that is why, lordship. And lordship, more than 2.5 years already passed. And they are young boy, lordship. And out of 17, only 7 numbers of witnesses examined.
Okay. Anything else?
Let him argue, lordship. If
Yes,
anything
Mr.
will be there, I will.
Lordship, first my argument, Lordship, this is a bail application, not a causing application. Now, Lordship, may please to see. Item 31, that's a main complaint because both are the accused.
Fiction.
Lordship may come to page 30. My learned friend has read out some portion.
Page
Page
30.
30, Lordship. Last 3 paragraphs. Bail application. Is a part of final complaint.
Yes. Yes.
Lordship, second last paragraph. Thereafter, all packets of morphine recovered from cavity. Lordship, please to mark that all that contraband was seized from the cavity made in the both the vehicles.
No.
Let me complete. What is the wrong answer? You may correct it. You will get your chance. Thereafter, all the packets morphine recovered from cavity after removing the nuts and bolts, plates behind the seat of driver and co-driver of Maruti Gypsy number so and so was given as P1 to P7 and P8 to P14 respectively. Then therefore all the packets morphine recovered from space under the seat of the driver and co-drivers of Maruti Swift Dzire number so and so given as mark 15 to so and so. Then on reasonable belief, an offense under section 8, which is punishable under section 21 of the act was be committed, and all these 24 packets were seized under section 42 of NDPS Act by Sri so and so intelligence officer. One by one weight of packets marked 1 to 24 was taken on electronic weighting machine available with the theme, and the weight was noted down in weight machine. Then it is returned, Lordship. Then all the procedure has been followed. Lordship has marked that in both the vehicles contraband were seized, where the present petition were there. Second, Lordship, come to my objection. Both the petitioners are the habitual offender in contraband, Lordship. They found to be involved in carrying on narcotic. That's why Lordship, that PIT NDPS Act was involved. Lordship, we come to my objection in bill application 2229.
Suhud Ali,
2229. Lordship.
2229, okay. Yes,
What's the paragraph 5?
yes.
Probably it is page number 75. Lordship. The final complaint was filed on 16/8/2022 before the Honorable District and Session Judge, Kamrup Guwahati. The charge has been framed and case is under evidence stage. 7 witnesses have been examined till date. 6. The other criminal records found against Ataur Rahman in special case number 3 of 2010 registered at PS Jagi Road, Morigao, which has been received a certified copy from the Honorable District and Session Judge, and record that the special case number 3 of accused Saudul Rahman, Ahmad Laskar, Ataur Rahman, and one another Abdul Haq Chaudhry were tried, and Atul Rahman and Sahud Ahmad Laskar were convicted by the Special Court of Marigaon, for which their involvement in trafficking of 1200 kgs of ganja in the case sentenced to RI for 10 years.
When they were convicted,
Lordship, in case number is written there, Lordship, date is probably it is not there.
so they have served out the sentence?
Yes, they have served and they come out of
They
the,
came out,
yes, yes.
okay.
Thereafter again they involved in the case, in carrying out the, this time morphine use. And Lordship, as submitted by my learned friend, charges were framed in April 2023. And out of 14 or 16 witnesses, 7 has been examined. And Lordship, may please to see the record. How witnesses were examined and who took time. And I have seen in two occasions, Lordship, the counsel for the defense took time, and probably 4 dates has been passed by taking time by them, Lordship. So in my humble submission, long incarnation is also not a ground here, Lordship, because witnesses are coming regularly and they will examine. And the record will speak. And Lordship has known that the constitutional bench has in Allahabad High Court that judgment. The time cannot be fixed, and particularly in case of criminal trial, Lordship, no time can be framed, and no court can direct the trial court to finish in a particular period also. Lord. And admittedly, Lordship, here the contraband was seized from the conscious position of the petitioners, Lordship. And they were earlier convicted, and prevention of NDPS Act was imposed on them.
Is it a bar in granting bail?
Yes, Lordship.
Any
In
authority?
my humble submission, Lordship, when they were found in same type of offense, the court should be more cautious while granting bail to them, Lordship. And Lordship has seen the order passed by this honorable court in. Lordship, pleased to see the order dated 13/6/2024. Passed by this honorable court in criminal WPC, Lordship.
Where
Lordship, in the 2229, page 85,
page?
probably 85, Lordship. My learned friend also pointed out. I want to read that order, Lordship. Order
Yes.
dated 13/6/2024.
Yes.
Heard Mrs. So-and-so, learned counsel for the petitioner, and so-and-so CGSC, and heard as a learned government advocate for 7 to 10. Paragraph 2. The petitioner's elder brother, namely Ataur Rahman, present petitioner, son of Allah so-and-so, Hojai, was detained in custody by order dated 27/12/2022, issued by the Government of India, Ministry of Finance, Department of Revenue, in exercise of power conferred under Section 3(1) of Prevention of Illicit Trafficking in Narcotic Drugs and Psychoactive Substance, directed to detain and keep him in the Guwahati Central Jail, Assam, so as to prevent him from engaging the illicit trafficking of the narcotic drug and substance in future. Peruse the said order dated 27/2022. The petition was detained in custody under PT NDPS Act 1988 on 18/1/2023. Agreed by the said order of detention 27/12/2022. Younger sister of the said detainee Adaur Rahman filed this writ petition. During the deliberation of the matter, the respondent and the Government of India have filed their affidavit on 10/1/24. During the pendency of the writ petition, 1 year period of the detention of the said detention pursuant to the impugned order dated 27/12/2022 has already expired on 17/1/24. Mr. K. Parashar, learned so and as well as S.K. Azharkar, learned government advocate, on instructions submitted that the said detainee Rahman is presently in custody and has been detained in Central Jail at Guwahati in connection with NDPS case number 3 of 2022, registered under section 8, read with section 21, in which he was admitted in the Central Jail on 1/3/2022. It is also been submitted that the said trial of the NDPS 3 of 22 is presently pending as NDPS case number so and so before the learned session judge Kamrup Guwahati. In view of the above, the petition in purchase stand dismissed and is still in jail. And Lordship is seen. He was
Still in jail for under this.
Yes,
for
this case. So in my information, Mr. Lordship, when there is a sufficient materials against him, and he was a Lordship, what he said, Lordship is a habitual offender in carrying on narcotic drugs. And more so, Lordship, when the contraband was seized from their physical position. And both the Gypsy as well as the Maruti Desire had a cavity, and it was in one Lordship, it was under the seat and cover of the driver.
They are traveling in
Yes,
Desire.
Lord, they were driving Lordship, and he was found there in the.
Yes, in Desire also
Yes, Lordship.
it was found.
My lord, may I?
So this is the materials, Lordship, and Lordship, again, Lordship has seen the final complaint in paragraph 5, probably that has been read by my learned friend, and I have read out some other portions where it is from both the vehicles contraband were seized, and the contraband was Lordship, it is
What is the commercial quantity of morphine?
50 grams, 50 grams,
Okay.
more than 50 grams. Here it is 12.040 kgs of morphine. 7 kgs were from Maruti Desire and 5 kgs from Maruti Swift Desire loads. From Gypsy, 7.7 kgs, and from Maruti it was 5 kg.
Yes, your main contention is that as the contraband was found from their possession, as they were earlier convicted for NDPS Act, as they were detained for under Preventive Detention Act.
Yes, Lordship. These are the sufficient
Therefore, they are habitual. Therefore, their benefit under for prolonged incarceration
cannot be
should not be granted.
And Lordship, furthermore, Lordship, there is, we cannot say that there is a prolonged incarceration, because Lordship, charge was framed in April 2023. And witnesses are regularly coming, and Lordship, even the counsel for the defense has took time on 4 occasions. Lordship, the record will speak, Lordship.
Okay.
And Lordship, in case of Supreme Court, in case of State of Bengaluru versus Polladi Ahmed, reported in Lordship 2022, Supreme SC page 56, in paragraph 11. Supreme Court. I'm giving earlier also given, today I'm also giving. I'm reading paragraph 11, Lordship. In this case, Lordship, Karnataka High Court granted bail to 4 persons. Then the agency, Karnataka High Court approached Supreme Court. In paragraph 11, however, the evidence brought before us against Muhammad Afzal A2, respondent in SLP number so and so, subject matter of the second case NCB number so and so, was also granted bail by order dated 8 January 2020. Will have to be treated as an entirely different footing. There are specific allegations leveled against the said respondent regarding recovery of substantial commercial quantity of drug from the rented accommodation occupied by him pursuant to which he was arrested on 16 June 2019. This aspect has been completely overlooked while passing the order dated so and so, wherein the only reason to appear to have waited with the High Court for releasing him on bail is that his case stands on the same footing of accused A and accused 3 and accused 4, and who has been enlarged on bail by the order dated so and so. And so and so, in connection with the second case registered by the department, we are of the firm view that accused 2 cannot be seek parity with the aforesaid accused, and no such benefit could have been extended to him in view of section 1737 of the Act, when he was found to be in conscious possession of commercial quantity of psychotic substance as contemplated under NDPS Act. That being the position, the petitioner NCB succeeds in SLP number so and so, the bail granted to the petitioner Mohammad Afzal is cancelled forthwith at this stage, and he is directed to surrender before the session. And Lordship, recently, Honorable Supreme Court in case of Lordship, paragraph 11 of this judgment. And Lordship, recently on 16th July, Honorable Supreme Court in the case of State of Meghalaya versus El Silo, paragraph 5 to 8. I'm reading paragraph 6, Lordship. While considering the essays under NDPS Act, one cannot be oblivious of the object and reason for bringing the said enactment after repealing the then existing laws relating to narcotic drugs. The objects and reasons given in the case itself reads as thus: an act to consolidate and amend the law relating to narcotic drugs to make stringent provisions for control and regulation of operation relating to narcotic drugs and psychotic substance, to provide for the forfeiture of the property derived from or used in illicit trafficking in narcotic drugs and psychotic substance, to implement the provision of the of the twin condition of section 37 NDPS Act are not satisfied, and sole reason that the accused is an HIV patient, that is the facts of this case. So Lordship may consider paragraph 5 to 8 of this judgment also. And moreover, Lordship, narcotic, more than commercial quantity of narcotic has been recovered from the conscious position of the petitioner. And Lordship, your incarnation Article 21 will, in my humble submission, it will not come into play in this case also. And along with my objection, I have annexed few judgments of Honorable Supreme Court for consideration of your Lordship.
What are these judgments?
Lordship, these are.
What is Nawaz Khan?
One is Nawaz Khan.
Which para you are relying?
Amlet. This is mainly relating to conscious position.
Nawaz Khan is regarding conscious possession.
Yes, mainly conscious position. In this case, Lordship, bail was granted, then Supreme Court cancelled the bail. Paragraph 17, 18, 19. And 20, Lordship.
Any other judgment?
Lordship, another judgment is annexed TLB. One judgment passed by this Honorable Court. Then Lordship, another is Union of India versus Ajay Kumar Singh.
What is Ajay Kumar Singh's judgment?
Ajay Kumar Singh, Lordship, regarding conscious position and compliance of section 37, Lordship. paragraph 11 onward, Lordship.
Okay.
This is my
Main plea is, apart from other pleas, his previous conviction
previous conviction and conscious
and
position
habitual
offender.
offender. Conscious possession materials are there,
Yes, Lordship, materials are there.
though they have taken plea that,
They may take plea, Lordship.
but as of now, materials are there.
Materials are there. Charges been framed against them. Evidence is going on.
But their plea is okay. Yeah, what is your reply? Done.
Lordship.
Finished.
And long incarceration cannot be ground in this case.
My lord, in this case, what my learned friend has submitted that cavity in both the vehicle, that is wrong, Lordship. It is mentioned in the final complaint that from the Swift Desire, they have stated in paragraph number 5 that
From the backside of the seat of driver
driver
and co-driver.
co-driver.
In Swift Desire
there is no cavity, Lordship. There is no cavity at all, Lordship. As per the paragraph number 5 and all the deposition of the prosecution witnesses, Lordship. Only cavity was in the Maruti Gypsy. There was nut bolt and that was open, Lordship.
No, there is mention in
No, Lordship, there is no
page-
cavity in the
30.
page.
page 30, but it is not, there was no cavity, Lordship. Page 30, at around 18:30 hours, searched Maruti Gypsy vehicle registration number so and so and so while searching the Gypsy and after removing the nut bolts of the seat belt plates which located behind the seat of the driver and co-driver, it was found special made cavity in the body and it's a Gypsy. It's regarding Gypsy, Lord.
Okay, but in your Swift Desire also, space under the seats of the driver and co-driver.
Yes.
Under the seats.
Under the seats means where they are sitting under there. There was no cavity as he mentioned, Lordship. There was no cavity, Lordship, as per their complaint, Lordship.
No, it was under the seat, it was concealed.
No, it was not concealed position as per their complaint, Lordship.
No,
And it is mentioned in their deposition also, Lordship. It was under the seat, Lordship.
Under the seat.
Seat means seat because under the seat there are open place, Lordship. Under the seat.
Okay.
Lordship, that is not clear as per the final complaint. Then, Lordship, what happened in this case? Lordship passed a order in favor of the accused because in this case, four number of accused in the final complaint, Lordship. One is, Lordship, there two are in Maruti Swift Desire and one in Maruti Gypsy and one another from another place. 4 accused were there. And out of 4, Lordship granted bail regarding this incarceration after passing the order of Honorable Supreme Court, what they have annexed, Lordship.
To whom bail was granted?
Manjinder Singh, Lordship.
The
Manjinder Singh,
fourth person.
4th person. That is in paragraph number 21. I'm giving that order, Lordship. It is passed on, Lordship, 2024, 28 April, Lordship. In paragraph number 21, it is clearly mentioned, Lordship, from 19. In the instant case on perusal of the material available on record, it appears that the only materials are 67. Then the 20 is the Apex Court has observed in Katina of rulings that any procedure which does not ensure speedy trial for determination of guilt of a person who is undergoing incarceration for a long period would not be regarded as a reasonable, fair, or just procedure and would fall foul of Article 21 of the Constitution of India. Though the Section 37 of NDPS Act 1985 provides for stringent provisions for grant of bail, however, Section 36(1) of the NDPS Act 1985 also mandates the government to constitute as many special courts as necessary for the purpose of providing speedy trial of the offense under the NDPS Act. If speedy trial is not provided to an incarcerated accused, it will certainly have a negative impact on the rigors of Section 37 of NDPS Act. This court is of considered opinion that for whatsoever reason, if delay has been caused, and if it is not due to any fault of the petitioner, then keep him under incarceration for long period, one hand, and to cause delay, culmination of the trial, on the other hand, would certainly be violative of his fundamental rights guaranteed under Article 21 of the Constitution. Then Satyendra Kumar Altil also discussed, Lordship. I would like to place this judgment, Lordship. So after that, Lordship is signed, please. And one more judgment referred by Learned PP. Then Lordship here regarding this Meghalaya High Court dismissed, Meghalaya High Court case dismissed by the Supreme Court, what was granted by the Honorable Meghalaya High Court. That was, Lordship, what happened. The bail was granted to Lalrintunglung Silo. So then what happened in this case? This accused person got the bail because she was suffering from HIV positive. That is why bail was granted. But Honorable Apex Court directed her to appear to surrender before the authority within a stipulated period. That was also extended, but she did not cooperate with the investigating authority. That is why her bail was cancelled, Lordship. That's the crux of that case, Lordship. So right now, Lordship, in our case, they are in the same footing in Lordship order, Lordship. They were 37 also discussed, and Article 21 and 36(1) also discussed. So other judgment, Lordship, relied in that case, I will place other also.
Heard Miss S. K. Nargis in both the cases separately. Heard Miss S. K. Nargis. Any submission? More submission?
Only one point, Lordship.
Yes.
Just for
Before Lordship, before starting, Lordship, this is one more judgment. Javed Ghulam Nabi said to that regards Apex Court judgment, Lordship. It is passed on.
Javed Ghulam.
Yes, 3rd July 2024. In this also, Lordship, Article 21 and the accused regarding this Article 21 also elaborately discussed. So, Lordship,
NDPS case.
NDPS case, Lordship.
Bail was granted.
Yes.
Yeah.
NDPS. UAPA, then UAPA also discussed here in this case.
UAPA is not required.
NDPS also discussed here, Lordship, regarding Article 21.
You mark the paragraph.
Yes, Lordship. I'll place this.
Yes.
Lordship, page 62. My
62.
learned client has submitted that one accused has been granted bail. Nothing was recovered from him.
Page 62.
Majinder Singh. His role has been explained here.
Yes.
His role has been explained, Lordship, in page 60 and 61. Role of present two petitioners has been explained.
Okay.
Lordship, in recent judgment of Honorable Supreme Court in paragraph 5, 6, 7, and 8 may kindly be perused.
Which one?
That the Supreme Court judgment pronounced on 16/7/2024. That Meghalaya.
Lalrin.
Yes.
Silo.
Silo.
Paragraph?
5 to 8, Lords. I've written on the top. This is my humble submission.
Silo did not cooperate with the investigating
Lordship,
authority. After several
She was
directions-
granted bail by the learned Meghalaya High Court on the ground that she is suffering from HIV. That ground has been negated by the Honorable Supreme Court. That cannot be a ground for
No,
granting bail.
not for HIV. We are not done on that. She has not cooperated
Lordship,
with
may please to
the.
see the judgment.
Yes,
Okay.
it is rather
Whether she
help
has-
us, Lordship.
Whether she has
It is-
cooperated or not, I'm not. what Honorable Supreme Court has observed, that is important to
We
me.
will also place that part, what is related to us, Lordship, in silent.
In complaint cases, under what provision investigation is conducted?
Lordship,
Where is the provision?
in the NDPS Act 6, we have to file, there are two systems, Lordship, by the police, they are filing charge sheet,
So after filing FIR, investigation is done according to CRPC.
CRPC.
In complaint cases,
Lordship, we are
where
filing.
NDPS,
NDPS,
where NCB is doing filing complaint.
yes, under section.
Under what
36.
provision they are
Section
conducting?
36, was section 36 capital A. Lord.
Section 36,
Yes, Lordship.
1A. No, my query is under what provision they are conducting investigation?
Lordship, CRPC.
CRPC investigation can be done only after filing of FIR.
No, Lordship, because we are taking under section 173.
No,
We are following.
Have you understood my question?
Lordship,
In complaint case,
yes, Lordship,
the court take cognizance after filing of the complaint.
Lordship.
Court can take either on police report
Or
or on complaint.
yes, Lordship.
So in NCB cases,
Let me come to page section 36 capital A.
this is not related to this question, but
May I explain, Lordship?
Lordship, may please to see. Section 36, offense tribal by special court. Notwithstanding anything contained.
36?
36 capital A.
Yes.
Offenses tribal by special
36.
court.
Yes.
Notwithstanding anything contained in Code of Criminal Procedure 1973, all offenses under this act which are punishable with imprisonment for term more than 3 years shall be triable only by a special court constituted for an area which the offense has been committed, or where there are more special courts than one of such area by such, then B, where any persons accused of and suspected.
No, my question is not regarding trial, neither regarding forwarding of the accused. It is regarding investigation.
No, investigation under CRPC laws.
But in CRPC, investigation can be done only after filing of FIR.
No, Lordship, but here we are because there is a special.
Which is the authorizing provision, which authorizes NCB to conduct investigation.
Lordship, there are.
Today you need not to answer. We will meet on some other day.
There are some notification of Ministry
Yes.
of that is there authorizing.
To the trigger.
Lordship, NCB.
You can also today.
No.
NCB, DRI and custom also.
can-
They are the authority which is empowered under this act to investigate in the matter.
Notifications.
Yes,
are
it
there.
is there. I'll place before you. Lordship.
You place those notifications.
Yes,
My
Lord.
lord, what
Yes.
happened in this case, in such type of case, on the, what cases are based on the complaints? In that case, Lordship, what happened, the 207 was there. So for this Lordship, 200 also there, for Lordship, CRPC, for filing of complaint. Until 2013 Lordship, it was based on the complaint, then after filing of the complaint, cognizance took after taking the evidences before search. Then thereafter, again charge frame, then this procedure or summon procedure was there. But in the year 2013, this honorable court has passed an order in Samsul Haq Talukdar case, Lordship.
In Samsul Haq Talukdar, the sessions tribal process would be followed.
Yes, that was discussed.
But regarding investigation,
Yes,
Lordship, chapter 5 probably is the answer to your Lordship query.
chapter 5.
Lordship,
Chapter five.
procedure. Start from section 41. The entire procedure has been written here, Lordship.
Okay, I'll go through. You also sometime.
Definitely.
This is just a general query.
Yes, Lordship. And I'll obtain all the notifications authorizing the agencies. Lord.
Release this matter for delivery of orders on 4th of September, no, 4th of November, October,
October.
October 2024.
Yes.
My lord, can I place that application which we filed before the authority will hand it over these things to him also?
What application?
regarding keeping the CCTV footages.
No, I will reflect it. You have made submission that is.
And Husainara Khatun and all, I will place it. Oh, it will be. It should give it a side.
22 incident. This is some other case.
Some other case in same footings, Lordship. This is about 3 years. 3 years, Lordship.
When were you arrested?
I was arrested, Lordship, on 14/10/2020.
14/10/2020.
3 years, 11 months.
Who is the petitioner?
Petitioner is Lordship
Mithilesh Kumar.
Mithilesh Kumar. Mithilesh Kumar.
3 years.
3 years, 11 months, 16 days, Lordship. In this case, what happened, Lordship? 3 persons were arrested. Then thereafter trial charges submitted, final complaint submitted, Lordship. And then against the 3 persons, charge frame on 10/3/2022. And in the final complaint, total number of witnesses, 10 number of total, Lordship, 6 number of witnesses. Total, Lordship, 12 number of witnesses cited as witness in this case, Lordship. Out of all the witnesses examined except the PW's 5 is no PW 5 no 7. IO PW 10, Lordship. He is the IO in this case, Manoj Sauguna. And in this case, Lordship, this honorable court was directed to complete the trial within 6 months. It is in, what is it? It is in page number 43, Lordship. This honorable court directed to complete the trial on 2/5/2023 within 6 months, Lordship, and if not complete, then directed to release the person, Lordship, and direction is, Lordship, will find at page number 45. Page number 45 at the bottom, Lordship. May I read, Lordship?
Yes.
However, it is provided that the learned trial court shall plan a calendar of hearings suitably so as to ensure early disposal of the case, preferably within a period of 6 months, failing which the learned trial court shall consider for release of the accused on bail subject to suitable conditions. So thereafter, they could not complete the trial within 6 months, and this person was released by the trial court. Thereafter, Lordship, 10 numbers of witnesses they examined. But what happened, Lordship, on the last, after completion of the PW10 investigating officer, they again filed a petition before the trial court to re-examine the PW10, Lordship, just to materially exhibit the remnants of the samples. That was inadvertent.
What was the contraband?
Contraband, Lordship, it's a tablet. No? It's a morphine, Lordship.
How much?
Morphine recovered from their position, Lordship, 2.146 kg. Methamphetamine tablet, Lordship, not morphine. Methamphetamine tablets, Lordship. From, though it is mentioned totally at 2.146 kg, Lordship, but from individually that from their position recovered 1 kg like that, Lordship. It is mentioned in the paragraph number 5, Lordship. Lordship will find at paragraph number 5. And this person really 1 person as per direction of the Honorable High Court, and subsequently the other co-accused he approached before this honorable court. He also released by this honorable court on Yahya Khan Lordship. He released on 26/6/2024 at page number 56. This honorable court passed the order, Lords. And the deposition of PW10 not yet completed. Though trial was directed to complete in 6 months, still it is fixed in the month of December.
PW10 is the IO. Okay.
So here one only what my learned friend will reply. This person.
She knows what I will reply.
Yes, I know that is.
Maybe knowing because both of you are in many cases.
Yes. No, my lord,
So both of you know what would be each other's
Yes,
submission.
what citation he will rely and I will rely, both we know, Lordship. Because Lordship, one thing is that in this case, this person, he was visited the JMCH and he fled away. Thereafter, he again arrested and still he is inside desert for
The
more than
present petitioner fled away
fled away. Again, he arrested
from
and
JMCH.
Then Lordship, that part was bad, but right now we are I am cooperating with the investigating authority. Still, I'm inside the jail and always I am waiting for completion of the trial, Lordship. But trial is not concluded. Though even after directing the honorable court, learned trial court, Lordship, and always he is questioned to the learned trial judge when his trial will be concluded. That is why we filed a bail petition, long incarceration to that regard also. 3 years, 11 months, 16 days. For my fault, I'm suffering, Lordship. But now if Lordship give me a chance to establish me that I'm a good person, the Lordship kindly allow me to go on bail, Lordship, in this case. That is the thing, Lordship. With any stringent condition, Lordship.
Yes.
All the person are on bail.
What's the first submission that 6 months was fixed by the this honorable court. What's it that was in 2023. Thereafter, Supreme Court in case of
My lord, though my learned friend has showing that the direction should not be passed as per direction of the Supreme Court, but in our case, one case, Lord, recently on last Friday, the Honorable Supreme Court has passed the direction to complete the trial. Supreme Court itself passed the direction, Lordship, to complete the trial within 9 months, Lordship.
Supreme Court can pass any order under Article 142. There is no bar. Lordship, there is a paragraph dedicated to this issue in judgment passed by the Honorable Supreme Court on 29/2/2024.
Which
High Court Bar Association, Allahabad versus State of UP. Paragraph 27, 28.
What is the citation?
Lordship, it is 2024 0 Supreme SC page 169. I'm supplying copy to your Lordship. Paragraph 27.
Okay.
28, 29 to 39.
Furniture.
Lordship, I could not go through the lower court's record. Lordship will be surprised to see how the trial was conducted and who is taking time.
We are not.
Please, address I am addressing honorable court.
I am
Lordship,
conducting this bail.
Lordship, may please to see the orders of the learned trial court.
Yeah.
Everything will be clear. Whether I'm speaking, I'm submitting wrong or order sheet will speak. All the witnesses will completed, Lordship, except 10. Lordship, please to go through the order sheet of the trial court that has come before your Lordship.
Okay.
So in my humble submission, Lordship, there is no delay.
When he fled away from GMCH?
That Lordship.
Before starting the trial, Lordship.
When how he was arrested?
He was arrested by their department, Lordship, again.
From where?
From his house.
Okay,
Then what happened, Lordship? All the witnesses examined after his arrest. He was cooperating, Lordship, since the date of arrest, Lordship.
And Lordship, we're pleased to mark the conduct of the petitioner also. And since the trial has been already completed, only cross-examination of witnesses there. And Lordship, we're pleased to see the order sheet. Because I could not point out Lordship dates and others. So in humble submission, Lordship, this judgment placed by me in earlier cases is also applicable in this case also.
okay.
And Lordship, page 39 of the complaint, the bail application, the role of the present petitioner is set to look.
Regarding room. Okay.
Page 39,
Page 39.
in the instant case, 839 grams of methamphetamine tablet from the recovery from the direct physical possession of the present petition, accused petitioner Mithlesh Kumar, which is more than 16 times and commercial quantity specified by methamphetamine tablet under notification number so and so.
Okay. Ms. S.K. Notice, counsel for the petitioner, also Ms. A.C.K. Learned Sterling Council NCB. Let this case be listed for delivery of orders on 4th of October 2020.
Much of it.
My lord's order is at page 56, Lordship,
Of the co-accused.
of the co-accused, order passed by the trial court. Lord. I have annexed.
On 4th.
Obliged.
Read compass. Admission matters are still pending. Admission কিমান আছে? Ms. Chaudhary will take up your matter at how much time will you take?
Normally it will take from 2 to 4:30, but it has not started yet, so Lordship.
So today it is unlikely to complete.
Maybe,
But you can,
Lordship. I'll try to complete, Lordship. 3:30, if your Lordship can complete all other matters.
yes, let
At-
me finish other matters.
At 3:30, Lordship,
As soon as other matters are finished.
Lordship.
3:30 tomorrow. This I have dictated half I have dictated. So I will reserve this judgment.
Lordship.
After vacation, I will deliver it.
Lordship.
Heard Learned Counsel, heard Mr. S.H. Rahman, Learned Counsel for the petitioner. Also heard Mr. S. Hawk, Learned Counsel for the respondent. Hearing concluded, judgment reserved.
Obliged, Lordship.
So under the Lordship, my friend's part was recorded, Lordship. That's a Lordship fixed today for the recording the my part, Lordship. Yes, Lordship. One part is completed, dictation, Lordship.
Your part is
Not recorded, Lordship.
you can do one thing. You can submit. I remember your.
Yes, Lordship.
I have taken notes.
I have no problem, Lordship.
No, I have taken notes. Your main case is that as the minor was removed by the mother when she fled away with the new husband. So is the place where the minor ordinarily resided should be should be the place where his original father resided. That is your case. But you can give in
Summary, Lordship.
a summary of your argument.
Yes, Lordship, then.
You may also give if you want, but I have recorded your submissions. You can give summary of your argument
Or
by 4th, tomorrow, day after tomorrow, or
The day after tomorrow, Lordship.
okay.
Lordship, my submission already recorded.
You need not to give. I have recorded your summary
Yes, Lordship, I'll give. it.
And next date is fixed on 2nd of November, Lordship.
of the
2nd of November.
okay. I'll try to deliver it before that,
Lordship.
after
Lordship.
Puja vacation. याते the note दी थोड़ा counsel for respondent will furnish written argument. You have to. Item number? Yes.
The appellant is the owner of the vehicle. The judgment is on page 37. Relevant paragraph is paragraph 20.
You were directed to pay the compensation.
No, the learned tribunal has directed the insurance
Insurance
company
and
to-
recover from you.
Yes, yes. Because of the finding is that I have no, the driver has no commercial license. Your lordship will see page 36. The entire report exhibit by the claimant. Page 36.
No, today we'll admit it. Admit it. This heard Mr. S.R. Gogoi, learned counsel for the appellant. Also heard Mr. S.P. Sharma, learned counsel for respondent number.
Respondent insurance company, Lordship, I have not received the copy of memo of appeal and.
No. You furnish him,
Yes, because it is.
respondent insurance company. This appeal under section 173 of the Motor Vehicles Act, 1988 has been filed by the appellant impugning the judgment and award dated 30/10/2012 passed in MSC case number 443/2015 by the Motor Accident Claims Tribunal, Nagaon. Stop. The appellant is aggrieved with the direction given in the impugned order regarding recovering the amount of the award from the appellant by the insurance company after paying the same to the claimant. Stop. The appeal is admitted. Issue notice to the respondents. Since Mr. S.P. Sharma has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards other respondents, the appellant shall take steps for issuance of notice by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 18th November 2024. Let also the case record of MSC case number 443/2015 be called for from the concerned tribunal. List accordingly.
Lordship, the name of my senior Miss R.D. Majumdar will be shown in the cause list.
Stop. The registry is directed to reflect the name of name of Miss R.D. Majumdar as engaged counsel for respondent number 1 in the cause list henceforth.
There is the I-4 stay.
Lordship, stay, my Lordship, the prayer may be after.
May I submit? There is the I-4 stay because as per 173(2), there is no need to deposit any money. Because immediately there is from the exhibit is shown that the driver has the valid license from the,
No, whether execution has been filed, execution application has been filed, or recovering from you, they have to file an execution case against you if you don't recover on your own. So execution has to be stayed. So let them file execution.
Let
them file a copy to us, Lordship.
No,
We will
because-
have to go through them.
he has no choice to appear today because no notice was issued to the insurance company. So.
Okay, then we are issuing notice.
Okay. So in the meantime, your lordship will stay the judgment of the decree.
No, judgment cannot be stayed.
Exactly.
Only execution can be stayed.
Suspend
Now,
the operation of the judgment.
uh,
Under order 41/5.
after service of notice, this interlocutory heard so and so. This interlocutory application has been filed by the applicant under order 41 rule 5 of the Code of Civil Procedure for staying the operation of impugned judgment and order dated 30/10/2018, passed in MEC case number 443/2015 by the Motor Accident Claims Tribunal, Nagaon. Issue notice to the opposite parties. This will be same like the main case. Place the matter again on date at this 18/11. The interim shall be considered after due service of notice on the opposite parties.
Deeply obliged.
Yes, what is this?
May please, your lordship. Lordship, this appeal has been filed mainly on the ground that this was a government servant, lordship. He was a sub-inspector of police working at Meghalaya, and he was traveling in a goods carrying vehicle, lordship, as a gratuitous passenger. So
Your
he-
insurance company.
Lordship,
Heard Mr. S.
R. Sharma.
R. Sharma, learned counsel for the appellant. This appeal under section 173 of the MB Act has been filed by the appellant insurance company, impugning the judgment and award dated 2/4/2012. Delay has been condoned.
Lordship,
2/4/2012 passed by the Motor Accident Claims Tribunal, Kachar, Silchar, in MSC case number 989/2007. Issue notice to the opposite parties and call for the case record of MSC case number 989/2007 from the concerned tribunal. The appellant shall take steps for issuance of notice upon the opposite parties by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
lordship. So there is an IA for stay of the order, lordship.
No, this is a very old pending case. After let them appear. Let them appear.
Please. Lordship, in this, we have filed the appeal on the ground of contributory negligence, lordship. That deceased was driving the motorcycle, and age of the deceased was not proved. The tribunal has considered 50 years.
Abhishek, same order. Only also heard Mr. what
A.
is-
Bhattacharya,
A. Bhattacharya, learned counsel for
claimants 1 and 2.
learned counsel for the respondent number 1 and 2. The impugned judgment is date change. Impugned judgment and award dated 29/12/2023, passed in MSC case number 1010/2021 by the Motor Accident Claims Tribunal, Kamrup Metro, Guwahati. Take steps within 4 weeks. Same.
on respondent number 3 and 4.
No. Since Mr. Bhattacharjee has appeared for respondent number 1 and 2, no formal notice need to be issued to the said respondent. As regards other respondents, the appellant shall take steps for issuance of notice upon the said respondents by registered post with AD as well as by usual mode within 7 days of the date of this order, returnable after 4 weeks.
IAB will deposit 50%.
In the interlocutory application, heard Mr. R. Sharma, learned counsel for the applicant, also heard Mr.
A. Bhattacharjee.
A. Bhattacharjee appearing for respondent number 1 and 2. This interlocutory application has been filed by the applicant/appellant for praying for stay of the execution of judgment and award dated 9/12/2023. 29/12/2023, passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro at Guwahati in MEC case number 1010/2021. Learned counsel for the applicant has submitted that the applicant insurance company is ready to deposit 50% of the awarded amount as a condition for grant of stay of the impugned judgment. Learned counsel for respondent number 1 and 2 has not opposed the said prayer.
However, we may be allowed to withdraw.
Said prayer. He has also submitted that on such deposit, the claimant may be allowed to withdraw the said amount. Stop. Considering the submissions made by learned counsel for the applicants, the notice to other respondents is waived. Stop. As the applicant insurance company is ready to deposit 50% of the awarded amount, this interlocutory application is allowed and the execution of the impugned judgment and award dated 29/12/2023, passed in MEC case number 1010/2021, is hereby stayed, subject to payment of 50% of the awarded amount, or subject to deposit of 50% of the awarded amount by the applicant to the registry of this court within a period of
4 weeks.
4 weeks from the date of this order. If such a deposit is made, the registry shall disburse the same to the applicant, who are the claimants?
Wife and son.
To Srimati Hashima Sahi and Shri Chandan Singh Sahi, comma, who are the respondent number 1 and 2, respondent/claimant in the main appeal, comma, after proper verification.
Without any rider, man. That will help us.
Without any
Rider.
what rider?
My lord, in the impugned judgment, there is a direction that out of the total amount of 30 lakh, 5 lakh to be released in favor of claimant number 2, that is the son. Then 10 lakh to be fixed for FDR. So these
15.
things will be,
What was the total?
total is 30 lakh.
So 50% will be given to you. Regarding other, this rider will be in play, applicable.
If your lordship say at least 50%, that is 15 lakh.
Otherwise, registry will calculate the proportionate amount. And then,
No, why it will calculate when there is no such order?
no, because the original award, there is a direction for 10 lakh rupees is to be fixed in fixed deposit.
Okay,
Then they will find out.
without any rider.
Much
This,
obliged.
this interlocutory application is accordingly disposed of.
Obliged.
May it please your lordship. Lordship, here the deceased was a government employee, Assam State government employee, lordship. He died, lordship. And the new scheme of compulsory
Okay.
family pension.
Heard
scheme.
Mr. T. Kolita, learned counsel for the appellant insurance company. This appeal under section 173 of the MVA Motor Vehicles Act is filed by the appellant impugning the judgment and award dated
Lordship,
4/3/2023 passed by the Motor Accident Claims Tribunal, Kachar, Silchar in MSC case number 612/2020. Also heard Mr.
Her name is not shown in the cost list, Lordship.
What is your name?
Sir, SK Singh, I am MK Neog on behalf of SK Singh. SK
Okay.
Singh is not well today.
What is your name?
MK Neog.
Mr. M.K. Neok, who is appearing for respondent number?
Claimant respondent.
Who is appearing for claimant respondent
Yes, Lordship. 1 to
within bracket respondent number 1 to 4. Stop. He submits that the name of the engaged counsel for respondent number 1 to 4 is not shown, are not shown in the cause list, and therefore prays that name of Mr. S.K.
Singha,
Singha and
MK Neog,
M.J. Neok,
MK.
M.K. Neok be shown in the cause list as engaged counsel for respondent number 1 and 4. Prayer is allowed. Registry to do so. Stop. This appeal is admitted. In citation below me, one appeal under 173. Why so? This appeal is admitted. Issue notice to the opposite parties, or notice to the respondents. Since Mr. Neog has already appeared for respondent number 1 to 4, no formal notice need to be issued to the said respondents. As regards the other respondents,
5 and 6.
the appellant shall take steps for issuance of notice on the said respondents but within 7 days from the date of this order by registered post with AD as well as by usual mode, returnable on 13th of November 2024. List accordingly.
I is there, lordship. I for stay.
Will you pay?
Lordship, we will be paying lordship as per the lordship ground set forth, lordship. Future prospect is entitled to them, lordship. So,
Are you ready to 50%?
lordship, it comes around 30%.
Then let them submit
After vacation,
objection.
Lordship can be. Next date, Lordship.
Or we'll let the other respondents appear. You want to,
I am just received copy.
okay, let them file objection,
On the stay, lordship.
stay, if they have any objection. In interlocutory application, this IA has been filed by the applicant / appellant under order 41 rule 5 of the Code of Civil Procedure, praying for stay of the execution of impugned judgment and award dated 4/3/2023 passed by the Motor Accident Claims Tribunal, Silchar, Kachar Silchar in MSC case number 612/2020. the said judgment and award has been impugned by the applicant by filing connected MAC appeal, namely MAC appeal number 482/2024. Issue notice to the opposite parties. Since the Mr. M.K. Neog has appeared for claimant / opposite party number 1 to 4, no formal notice need to be issued to the said respondent. The counsel for the said aforesaid respondent raised for some time for filing written objection against the said against the prayer of the applicant. The prayer is allowed. As regards other respondents, the applicant shall take steps for issuance of notice by other respondent not necessary.
Because based on quantum lordship.
So what is to be done?
They-
As regards other respondents, the notice is waived. We are waiving the notice.
In IA lordship, only in IA.
In IA. Let this matter be listed again on আগৰ date কি আছিল?
13 November.
30th of March.
Your Lordship. Lordship, this appeal has been filed on the ground of fraud.
Heard Mr. R. Sharma, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act.
Lordship.
Motor Vehicle Act has been filed by the appellant insurance company, impugning the judgment and award dated 7/9/2018, passed by the Motor Accident Claims Tribunal, Karimganj, in MSC case number 46/2015. 2015. The appellant has, what is this 2021 order?
Lordship, this is a review. We have also filed the review, Lordship. In this case, claimant has filed the claim petition. Two claimants filed the two claim petition in different district, Lordship, for the death of same person. Therefore, we have filed the review, Lordship.
The appellant has also impugned the order dated 29/2021, passed in Miss Review number 2/2019 by the Motor Accident Claims Tribunal, Karimganj, in connection with MSC case number 46/2015. Issue notice to the respondents and call for the relevant case records. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly. What is this?
IS for stay, Lordship.
After service of
Yes.
notice.
My Lordship.
May I please, your Lordship? After the delay condon, Lordship, the matter has come to the first time, Lordship. And Lordship.
Not
yes,
Mr. A. Burwa, learned counsel for the appellant. This appeal under section 173 of the MV Act has been filed by the appellants. Your claim was dismissed
Lordship, for enhancement, Lordship.
by the appellant / claimant for enhancement of the compensation awarded to the appellant by the impugned judgment and award dated 7/11/2017 passed by the Motor Accident Claims Tribunal, Morigao, in MAC within bracket D, case number 64/2014. Issue notice to the respondents.
So respondent already appeared in the IIL also.
But here you have to issue fresh notice. Unless they themselves appear.
And also the respondent number 2 is already struck off.
Okay, issue notice to respondent number 1 by registered post with AD as well as by usual mode. You can also serve notice on the council.
Today also my learned council was present also.
When?
Today itself, she left from the court lordship.
Learned counsel for the appellant submits that the appellant may be allowed to serve notice on the engaged counsel for the respondent number 1. Same is allowed. Let this matter be, let the case record of MAC within bracket D case number 64/2014 be called for from the concerned tribunal. Let this matter be listed after 4 weeks on receipt of the records of the from the concerned tribunal. List accordingly.
May I please? So this appeal is filed by the claimants for enhancement.
Heard Mr. M. Ahmed, learned counsel for the appellant. This appeal under section 173 of the MBA has been filed by the appellant/claimant, praying for enhancement of the compensation awarded to the appellant by the impugned judgment and award dated
29/6.
dated 29/6/2024, passed by the Motor Accident Claims Tribunal, Dhubri, in MAC case number 41/2019 within bracket D. This appeal is admitted. Issue notice to the respondents and call for the concerned case record. The appellant shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly. Heard Mr. A.R. Agarwala, learned counsel for the appellant. This appeal has been filed by the appellant under section 173 of the Motor Vehicles Act, impugning the judgment and award dated 29/6/2024, passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, Guwahati, in MAC case number 296/2020. This appeal is admitted. Issue notice to the respondents and call for the case record of MAC case number 296/2020 from the concerned tribunal. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Here, looks like the owner has denied involvement in his vehicle, and he was examined as DW. He has stated that his vehicle was not involved in the accident, but tribunal has passed the judgment, and he also said that police has called him to give his vehicular document. According to he appeared with the police. Total award was around 80 lakhs.
80 lakhs.
80 lakhs.
Heard Mr. S.K. Goswami, learned counsel for the appellant. Stop. This appeal has been filed by the appellant / insurance company under section 173 of the Motor Vehicles Act, 1988, impugning the judgment and award dated 1/6/2024, passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro at Guwahati, in MEC case number 1417/2018. This appeal is admitted. Issue notice to the respondents. Stop. Call for the case record of MEC case number 1417/2018 from the concerned tribunal. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly. Interim after appearance. We'll pass orders then.
Obliged.
May it please your lordship. Lordship, here the victim was a curious passenger traveling in a goods carrying vehicle, lordship. Lordship, may kindly see page number 29 of the appeal memo, my lordship. Page number 29.
Okay, we are admitting it. Heard Mr. T. Kolita, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act, 1988 has been filed by the appellant insurance company, impugning the judgment and award dated 25/6/2024, passed by the Motor Accident Claims Tribunal, Bongaigaon, in MEC case number 58/2019. This appeal is admitted. Issue notice to the respondents. Stop. Call for the case record of MEC case number 58/2019 from the concerned tribunal. The appellant shall take steps for issuance of notice upon the respondent within 7 days from the date of this order, returnable after 4 weeks, by registered post with AD as well as by usual mode. List accordingly. The interlocutory application after service of notice.
Much obliged.
Twenty-four Kuna Samantha.
Item 24.
So this is a judgment and decree of reversal. The plaintiff filed a suit for specific performance of contract against defendant number 1. The appellants herein were arrayed as pro forma defendants.
You are opposing?
Lordship, may I submit? Lordship,
No,
we-
no, I am asking if you are opposing.
Yes, Lordship.
How much time will you take?
10 minutes.
Lordship.
The substantial question of law is very simple because the plaintiff himself has failed to prove the sale deed by which he allegedly purchased from defendant number 2. And he is the person, my lord, against whom the decree is passed. Now he has not appealed, but he has filed the caveat here. He is appearing on caveat. The decree is against him, but he has not filed any appeal. He is appearing on caveat just to help the plaintiff case. But there is a collusion. This entire suit was filed in collusion with the defendant number 1. Defendant number 2 and 3 are the original land owners from where, my lord, the plaintiff has allegedly purchased. It is the allegation. It is the statement of the plaintiff. But somehow he failed to prove the sale deed executed in the years 1974. That's why his suit was dismissed on this ground. But in the appeal, the learned court of appeal has came to a finding that
We will take it up day after tomorrow.
Lordship, may I submit little bit? Lordship, actually, the allegations said by the counsel on the other side, we are denying it. And Lordship, actually, the memorandum of appeal is
No,
this.
not today.
Lordship, just a small prayer,
The
Lordship.
suit procedure
That-
ex parte against him. Now he cannot improve his with the pleading.
Therefore, it will be contested. It will not be over within 10 minutes.
And the predicament is, see the cleverness of this caveator. He did not file an appeal. That decree is against him. Now he is supporting the case of the plaintiff. So there is a collusion in filing the suit.
There
The
is-
collusion is apparent
No,
when
we
he-
have a part heard matter.
There is no such collusions, Lordship. Lordship, actually,
Not today. We have a
even
part
under
heard
order
matter.
41.
Lordship may take up the matter after vacation.
No,
Lordship.
why
Actually,
after vacation?
because we need to go through the memorandum of appeal, Lordship, and it has received just day
My lord,
before yesterday.
under
Lordship.
order 41, he doesn't have
not-
even right to oppose the substantial question of law, my lord,
No,
framed
he
by
may
this court.
appear there on fourth,
On 4th, my lord.
on fourth.
The caveated
Ye-
Lordship
ye-
requires some time to go through the matter, Lordship, and
On
argue the
fourth,
matter.
on fourth, you may make your
Yes, my lord.
submission. Heard Mr. S. Bishwas, learned counsel for the appellant. Also heard Mr.
And M. Ajar Bhuiyan,
N. A. Majar Bhuiyan appearing for
caveator,
the
the respondent.
aviator for the sole respondent.
Yes, Lordship.
There is only one respondent.
There is only one respondent. He is the plaintiff. And he is appearing on behalf of different number 1. He is not a party here because the decree is against him. Different number 1. He has filed the caveat
No,
on behalf of
who
different
is
number
the
1.
respondent in this?
Respondent is the main plaintiff. This is Govindra Chandra Paul.
He is appearing for the.
Govindra Chandra Paul is sir.
Well, in the caveat, we are being informed that different number 1 on behalf of different number 1, this caveat
No,
is
caveat
filed.
has been filed by Govindra Chandra Paul himself.
From the office, not
Heard
in the registry.
Learned counsel
Okay.
for respondent number 1. Let this matter be listed on 4th of October for hearing under order 41 rule 11 of the Code of Civil Procedure. In the meanwhile, you may furnish.
No, we have already furnished because he is appearing on caveat. Much obliged.
Obliged, Lordship.
আৰু কি থাকি যাব? Well, item number 46 and 47, item number 46 and 47.
May I take Lordship, indulgence to my lord 47, my lord. It is an urgent matter for
No,
me. my
but we have a part heard.
Yes, yes, my lord. Yeah, I understand, my
And
lord.
it will not, I don't think it will be over by today also.
My lord.
So hearing has to be postponed, 46 and 47.
My
Have-
lord, the date to can leave 46.
Okay, item number 46.
On
Do-
this.
Who is appearing for the, heard Mr. Ace G. Bhardwaj, learned counsel for the appellant. Also heard Mr. M.U. Mahmood, learned counsel for the respondent. Due to paucity of time, this matter could not be taken up for hearing today. Hence, let this be listed for hearing. When do you want?
Immediately after vacation.
Suggested date. Suggested date.
29th of
26th.
6th of November.
Uh,
5th of November, it's Tuesday.
6th of November.
6th.
5th of November, 5th of November. And yes, your
My
prayer,
lord, 47, my lord, I am appearing for the appellant. I have taken consent also for paucity of time today not possible. My lord, on 29 maybe, both the parties will be available. And my lord, I have,
on request of learned counsel for both the sides, let this matter be listed on 29th
29th
October.
October. My lord, I have another request, my lord. Lord, matter may be listed on the top of the list, my lord. But the problem is this, my lord, on several occasions matter is listed, but.
If
for
civil
prosecution-
case is listed in the top of the list, other list will collapse. Because
Then
hearing
as
matter,
a first item of the hearing, my lord.
on that day you make a prayer.
Yes, my lord.
On that day
Yes,
you may
yes.
make mention.
Yes, yes.
Nowadays, top of the list matters are coming as because from part two list, some matters, old pending cases are given in the top of the list matters. Part two will
On,
give-
on hearing days, on
On
hearing days, it may be taken up.
Hearing day, sometime
Then-
in motion day also, lordship. কলাখন হ'ব এতিয়া।
But my experience is
Lordship,
that it
it is
takes
better to take on the second half.
lot of time.
Yes, lordship.
Very short matter, my lord. I have very-
No,
Oh, yes, yes.
council says short matter, but they take whole day. That is my experience. So let it be on 29th.
29. On that day, my lord, I will.
You may make mention.
Obliged.
Yes, yes, Miss Chaudhary. Item number 53.
Yes, lordship. In this case, what happened, lordship, my learned friend has argued the matter. Your lordship heard his argument, but without apprising the court about the plaintiff's case, lordship. The appellant hampered on the weakness of the defendants, lordship. So I'll take the pain to travel to the area of plaintiff's case, lordship, and the judgments passed by both the courts. So lordship, first I will take your lordship to plain, lordship, that is annexed is page 39.
Just a minute.
Page, type copy is at 8 and the original is at page 17. Plain copy.
Page 17 of the memo for appeal.
Memo of appeal. Lord. This is the original plain and the type copy is at page 8. I'll read from the original copy, lordship, page 17.
Yes.
Page 17, lordship.
Yes.
Present appellants are plaintiffs, lordship, Raghunath Prasad Sharma and legal heirs of Mohendra Sharma, Shanti Devi, Mohesh Sharma, Gautam Sharma, Uttam Sharma, Om Prakash Sharma. So they are plaintiffs in title suit number 402/2005.
Yes, for eviction and.
Yes, lordship,
injunction.
against the defendants, there are two
No,
groups.
they, during their argument, they made submission that this was held to be barred by limitation
lordship.
as they failed to challenge the.
Khatian in the
Khatian.
course of time.
Yes.
So defendant one group is lordship represented by us. And defendant two group. Defendant number 5 from page 7. I'm just lordship apprising your lordship that about the parties, lordship.
Yes, yes.
1, 2, 3, 4 we are representing.
Okay.
And about group defendant number 5, group 2. They are tenants under us. They are represented by Mr. G.P. Bhomik. Now he is not appearing in this. Earlier he appeared in this case, lordship. So this is a case, page 18, for declaration of title for eviction and for perpetual injunction.
Whether order is there for proceeding ex parte against.
No, lordship, as because we have in the meantime stated that a third party was implicated during pendency of the RSA as respondent number 6, as he in the meantime purchased a part of that property. So main dispute is in between the appellant plaintiff and the third party and the owner, lordship, this group 1. Group 2, as per our information, they are not possessing right now, lordship. So they are not interested in this case.
So you are appearing 1, 2, 3, 4 and the third party.
Third party.
Okay.
In RSA, he is lordship substituted, implicated as respondent number 6.
6.
Their case, lordship, plaintiff is only 2-3 pages. I'll read the entire plaint. Plaintiff's father, late Sardar Lohar, had a tenancy of 15 katha of land under Koraibari measurement under landlords Narendra Khatun and Hamida Khatun, both wives of late Khan Bahadur Abdul Latif Khan. After acquisition of Jamindari of the landlords, tenancy of Sardar Lohar was erroneously recorded as government khas under Dag number 924 with area 1 bigha 1 katha 6 lesser at village Mankachar part 1. That on death of Sardar Lohar, his wife Ramrati Devi, two sons Mohendra Sharma and Raghunath Prasad Sharma filed title suit 618 of 1967 against State of Assam and obtained a decree on 23/11/1967, declaring title and possession of them and for correction of records, and accordingly land records was corrected in their names on 25/1/1969 in the names of decree holder under Khatian number 593, Dag number 924. So Lordship, they are, as per their title suit direction, their names were recorded under Khatian number 593. Dag number 924 with area 1 bigha 1 katha 6 lesa of Mankachar part 1, resisting the objections of defendant of group 1. So in para 1, they have admitted that under landlords Nur Nehar Khatun and Hamida, it is admitted by the plaintiff that Nur Nehar Khatun and Hamida are landlords. And in para 2, they have admitted that as per their order in title suit decree, their names were recorded as decree holder in Khatian number 593 and Dag number 924. That Sardar Lohar had his dwelling house over Dag number 924, and after his death, his widow and two sons, and after death of Ramrati Devi and Mohendra Sharma, the plaintiffs have been residing over the ancestral homestead on payment of regular revenue to the state. That on being evicted from tenanted house and land of Nurun Nehar and Hamida Khatun, the shelterless Mantu Saha approached to Mohendra Sharma for temporary shelter, and out of pity, he allowed him and his children to reside in a two-roof tin shed house on the southwestern side of the homestead of the plaintiffs of Dag number 924, specifically described in Schedule A at the foot of this plate, that the permissive possession of Mantu Saha continued in the said house, and after his death, the defendants of Group 2, most of them being minors, became so helpless the plaintiffs were to allow them to continue in the said shed house as mere permissive possessors. That of late, though the defendants of Group 2 became majors and have already constructed their own residential house within Mankachar Bazar area, they are not vacating the house of Schedule A on various pretexts, ignoring the repeated demand of the plaintiffs. That now it appears to the plaintiffs that to evade eviction from the house of Schedule A, the shrewd defendants of Group 2 and Group 1 have made some secret understanding among themselves by filing a collusive suit, White Title Suit number 266 of 1996, in the Court of Junior Civil Judge number 2, wherein defendants of Group 1 claiming the land of Schedule A to be land of defendant of Group 1 under Khatian number 5, filed a suit for evicting the defendants of Group 2 as defaulted tenant of them, and the house rented to them is required to be reconstructed. And as the defendants of Group 2, by denying title of plaintiffs, set up their own title, plaintiffs filed petition for joining the suit as defendants, but his petition was rejected on 6/12/2004, Lordship, which compelled the plaintiffs to file this suit. That Khatian number 5 is a fictitious Khatian without any authority of issuing. Inquiry is still running against it. Deputy Commissioner Dhubri has suspended it, refused to issue any copy of it to anybody. It has no source in the land records, the land being acquired under Jamindari Acquisition Act, Mina Muhammad Ilyas, the father of defendants of Group 1, taking landlords Nurun Nahar and Hamida Khatun with him, filed a petition under Section 103 of Gwalpara Tenancy Act for correction of records in their names, claiming 1 bigha 1 katha 6 lesa of Dag number 924 to be their Tauji land in MNK 6 under section 103 of 6162, where a petition was filed to correct the records in the name of Mina Mohammad Ilyas by striking the names of Nurun Nehar and Hamida Khatun on the basis of a gift deed prepared subsequent to acquisition of the land under Jamindari Acquisition Act, wherein compensation for acquisition was already obtained, that in consequence of previous acquisition and subsequent claim of title over acquired land on the basis of a gift deed made by original landlord Nurun Nehar and Hamida Khatun, the learned ARO first struck off the names of landlords and subsequently struck off the claim of Mina Mohammad Ilyas based on title of landlords, and thus on 6/9/65 MNK 6 under section 103 of GT Act was dismissed and finally disposed of. So, Lordship, it is admitted that our claim was based on landlords. We are claiming equal to landlord status, Lordship. It is admitted by plaintiff, Lordship, that even after dismissal and disposed of the said MNK 6 under section 103/6162 on 6/6/65, and even after decree of title suit number 618 of 67 on so and so in favor of plaintiff by manipulation of records on 25/6/68 without any order of any authority for creation of any khatiyan in the name of Mina Mohammad Ilyas, an illegal note has been made on 10/7/68, and on the basis of no such order claimed to be made on 10/7/68 by ARO, a fictitious khatiyan number 5 was created in the name of Mina Mohammad Ilyas with respect to Dag number 924, which can never confer any title to him or to the defendant of Group 1. That to frustrate the conspiracy of defendants' collusive suit of title suit number 266/1996 over the plaintiff's decretal land, plaintiffs are compelled to file the instant suit. Now, Lordship, the prayer portion, decree declaring title of the suit house of Schedule A as being within their residential compound of decretal land of Dag number 924 of Khatiyan number 593. A decree declaring that land and house of Schedule A is not the rented house of defendant of Group 1, nor it is over the land of Khatiyan number 5. A decree declaring that the very Khatiyan number 5 of defendant of Group 1 is issued by manipulating of records. It has no source or legal sanction and can confer no title to the defendants of Group 2. A decree declaring that suit land and house of title suit number 266/96 being owned by plaintiff, any decree passed therein is invalid and unenforceable in law. A decree declaring the defendants of Group 2 being permissive possessor over the land and house of Schedule A who fraudulently by denying title of plaintiffs have trying to set up title of themselves, they are liable to be evicted therefrom. A decree of eviction of the Group 2 defendant of Group 2 from the house and land of Schedule A. A decree of eviction of the defendant of Group 2 from house, a decree of perpetual injunction. So these are their prayer, Lordship. Here they have already admitted that Nur Nahar and Hamida are owner. They are tenant, Lordship. And our case, as per their title suit, their names were recorded in Khatiyan number 593. Dag number 924, and with an area of 1 bigha, 1 katha, 6 lesser. And Lordship, we have done some fraud, but there was no such specific pleading regarding fraud, Lordship. Now your Lordship will come to title suit, Lordship, judgment. PW1, they have adduced the evidence 1 to 14 copy of exhibits, though I have found only 1 to 13 copy of exhibits, Lordship.
They have used only one evidence, only one witness.
PW1 and PW2. PW2, I think. PW2 also. PW2 is there. Now trial court judgment, Lordship. Total 8 issues were framed by the trial court.
Page,
Page 78B. First page, and issues, Lordship, 78 and 79. First is whether the suit is maintainable in its present form, whether the suit is barred by limitation, whether the plaintiff has valued the suit properly, whether there is any cause of action for the suit, whether the plaintiff has right title over the suit house schedule A, whether the defendant acquired title by adverse possession, whether the plaintiff is entitled to a perpetual injunction, to what other reliefs. In this case, Lordship, I will only read issue number 2, that is suit is barred by limitation. And Lordship, the issue number 5 and 6, though there was no challenge to issue number 6, but I will read issue number 6 also, Lordship. In issue number 2, Lordship, page 79. As I am not reading all the other issues, only because the fact that the trial court decided those issues, and thereafter in first appellate court, they remain silent in attacking those issues, Lordship. So I am not reading those issues, Lordship. Page 79, issue number 2, whether the suit is barred by limitation.
yes.
The plaintiff in his plaint has stated that the cause of action had arisen on 6/12/2004 when the learned trial court entitled suit number 266/1996 dismissed the petition for getting them impleaded in the suit. Plaintiff has been claiming right title on the suit land on the basis of decree obtained in title suit number 618/1967. The plaintiff has alleged in the present suit that the defendants have instituted a collusive landlord-tenant suit on the basis of Khatian number 5 in the year 1968. Now, as regards the computation of period of limitation is concerned, it should be counted on the day on which cause of action for the suit has arisen, which again must emanate from an illegal act. In the present case, the plaintiff has alleged that the cause of action has arisen on 6/12/2004, on which the learned trial court entitled suit number 266/96 had dismissed the petition for getting them impleaded in the suit. I am of the considered opinion of the decision or the court which has a legal validity cannot give rise to a cause of action, and period of limitation cannot be counted from that day for that matter. For the grievance against such decision can be redressed by approaching appellate authority, thus such a date cannot be considered for computing the period of limitation. The plaintiff who denies the right title of the defendants on the suit land, alleging that alleged Khatian number 5 is fraudulent, should have moved proper authority for cancellation of the same, and only on being denied for the same, they could have come to the court for declaration of right title on the suit land. And since their alleged Khatian number 5 was made in the year 1968, cause of action has arisen that time only, since the plaintiff were either acquiescent on the matter or was slumbering upon the rights. I hold that the suit is barred by limitation. So, Lordship, the rejection of their impleadment petition will not give a period of starting point, as because against that order, they could have filed any revision before High Court, Lordship, for impleadment in that suit. That was not done by the plaintiff. And it was, the Khatian was prepared in the year 1968. Even the civil court cannot cancel a Khatian, Lordship. The power is vested upon settlement officer and deputy commissioner, Lordship. For that, Assam Land Revenue, Lordship, specific provision is there.
Which is the page, same book.
Same book, Lordship. Then page 171 or 169 it started. Preparation of record of rights of tenants and others, Lordship. Though it is not in regard to tenancy, but Lordship, it was prepared under Gwalpara Tenancy Act. So Lordship, the procedure is followed by these provisions only. Different processes in preparation of record of rights, Lordship, that is Regulation 79, Rule 79, Lordship.
Yes.
When an order has been made under Section 17 of the regulation directing that a record of tenants and others' rights shall be prepared in the manner prescribed below and shall consist of the following processes: preliminary survey and record writing, record attestation, preliminary publication, disposal of objections, preparation of final record, publication of final record, distribution of final record. These were done during settlement process, Lordship. Draft Chita prepared then 81 Khatiyans and record attestation, Lordship. In our case, as there was a direction from civil court, Lordship, so Khatiyan was prepared. That will come under, Lordship, 118, page 184. Alteration of registers on decrees of civil code. On the basis of ARO's order, Lordship, our Khatiyan was opened. Khatiyan number 5, Lordship. Our name of 1 bigha 1 katha 6 lesa was incorporated in Khatiyan number 5 on the basis of ARO's order, Lordship. Assistant Revenue Officer, and that officer's order is a, Lordship, equivalent to civil court's direction, Lordship, as per Gwalpara Tenancy Act. So 118, Lordship.
But the counsel for the other side, while making submission,
Lordship.
he referred to an endorsement in the Sita,
Yes, Lordship.
which is by Lat Mandal,
Lordship.
where there is no mention of the ARO's order.
No, Lordship, it is mentioned in the ARO's order. The name of our landlords were corrected as per order of ARO only, Lordship. There is an order, it was exhibited also, Lordship.
You have to show me that.
Yes, Lordship, I will show. Alteration of registers on decrees of civil code. It can be, Lordship, incorporated on the basis of decree or field verification during settlement, Lordship. Whenever any civil court makes a decree confirming any transfer of possession of a transferable estate or gives effect to any decree transferring any such possession, such court may order the transfer to be registered in the General Register of the Deputy Commissioner, and the Deputy Commissioner shall register such transfer accordingly. So, Lordship, there is a provision to incorporate the name under when there is a civil court direction. Now, Lordship, after publication of that record of rights, 82F, page 172. When it can be challenged, Lordship. And by whom, Lordship? Not by a civil court, Lordship. Settlement officer may correct record of rights within 2 years of termination of operations. Page 172.
Yes.
The settlement officer, or if there be no settlement officer, the deputy commissioner. So power is vested only upon settlement officer and deputy commissioner. May, on application or of his own motion within 2 years of the date of the notification under section 19 of the regulation declaring settlement operations to be closed, correct any entry in a record of tenants' rights which he is satisfied has been made owing to a bona fide mistake. Provided that no such correction shall be made until reasonable notice has been given to the parties concerned to appear and be heard in the matter. So as per this, Lordship, the record of rights cannot be cancelled by a civil court also, Lordship. So there is a provision within 2 years. In 1968, Lordship, they have, the Khatian was prepared and they remained silent, Lordship. Since 1968, in the year 2005, they filed the suit, Lordship. Now, issue number 5, whether the plaintiff has right title over the suit land of Schedule A, page 80, Lordship.
You are claiming your right on the basis of Khatian number 5.
Yes, Lordship. We are not claiming as because we are defendant. There is no counterclaim. Plaintiff has filed the suit and plaintiff has to stand on his own foot. Lordship. But with the, instead of that, they are hampering on the weakness of the defendants, Lordship. Whether the plaintiff has right title over the suit land of Schedule A,
Page number?
page number 80.
Yes. Issue number?
Issue number 5.
Yes.
Schedule A is the house of measuring 22 into 9 cubits standing on the land cover under Dag number 924 having area of 1 bigha 1 katha 6 lesser recorded under Khatian number 593. So their claim is, Lordship, under 593 Khatian. The learned counsel from the plaintiff side has argued that ownership of the suit land was declared in favor of the plaintiff by the Munsif Court Dhubri in title suit number 618, 1967. But he alleges that the defendants fraudulently created a Khatian number 5, getting their names recorded as Pattadar. Therefore, they argued that the suit land be decreed in their favor by virtue of the said title and the defendants be evicted from the suit land. The learned counsel for the defendant side, on the other hand, argued that the suit land agreed in the alleged title suit number 618, 1967 amounts to 9 lesa and for which a separate Khatian number 945 has been created. And hence the suit land has nothing to do with the land in possession by the defendants as well as the land covered under title suit number 265, 1996, and hence the plaintiff has no right title over the land claimed by them. The plaintiff has examined as many as 3 witnesses in support of their claim. The plaintiff in his evidence in chief has stated that they had filed a suit bearing 618, 1967 against the government as against the declaring the land under Dag number 924 covering land 1 bigha 1 katha 6 lesa at village Mankachar to be cast land and obtained a decree on 23/11/1967 declaring title and possession and for correction of record of Khatian number 593 and Dag number 924. The plaintiff has exhibited Exhibit 4 as the decree of the against government in the title suit number 618, 1967. On perusal of the Exhibit 4 through the suit, the plaintiff had claimed for declaring right title interest on a land measuring 9 lesa and for that directing government of Assam for creating a separate Khatian by segregating the said land of 9 lesa from Khas Khatian number 1 and Dag number 924 and creating a separate Khatian. So Lordship, pausing for here for a moment, Lordship. Though in plaintiff they stated that their claim was for 1 bigha 1 katha 6 lesa, but instead, Lordship, all the exhibits shows that their plaintiff itself shows their claim was only for 9 lesa, Lordship. So that 9 lesa was separated, segregated from Khatian number 1, government Khas Khatian.
No, on what basis you are saying so?
Exhibit is there, Lordship. Exhibit C is also there, Lordship. The plaint of that title suit, 617. 618, 97, Lordship. 618 of 97,
On the basis of
we have exhibited, Lordship. Exhibit C,
618 was their suit,
their suit, Lordship.
on the basis of which
They
entry in the
claim-
Khatian was made.
Yes, Lordship. Their Khatian was
What was the area of land in
15 chatak, Lordship. Specifically made in that petition, only 15 chatak.
where it is mentioned?
Exhibit C, your Lordship will find from the LCR.
Exhibit C is you have exhibited that.
Yes, Lordship. Their petition I have exhibited as they have exhibited my rejection order, Lordship.
Exhibits. Good.
There is a flag mark, Lordship,
রাখি।
exhibit 1 to 13 in C5.
একদম ঠিক নাহলে পাতি exhibit C.
Yes, Lordship, 1 to 13, and below that exhibit A, B, C are there, Lordship. I have flag marked 1 to 13 only. After 13, A, B, C are there. No, A, B, C 2 flag mark for now. Extra copy also. Yeah, because extra copies. No, wait. Wait.
Certified copy of the petition.
Yes, Lordship. Lordship will find there is a number 61867. TS 61867.
Just in. Yes.
Below the exhibit mark, Lordship, below the
Yes,
exhibit stamp. Badi Srimati Ramrati Devi Sami, wife of Sardar Lohar. Present plaintiff's mother, Lordship. Raghunath Prasad Sharma, plaintiff number 1. Pita Mrito Sardar Lohar. And another one is Sri Mohendra Prasad Sharma, Pita Mrito Sardar Lohar. Hokolor Jati Hindu Sang Mankachar Thana Mankachar Jila Gwalpara. Bonam Bibadi Ahom Sarkar Shillong. Sotto Dokolor Ghoshona Khottian Hongshudhoনৰ মোকদ্দমা দাবী 100 টকা বাদী পক্ষৰ গোচৰৰ বিৱৰণ এই যে নিম্নতৰ something written এলাকাধীন নিম্ন বৰ্ণিত কৰাইবাৰী মাপৰ 15 চটাক 15 চটাক here written, Lordship.
Read complete.
15 চটাক মাটি খান বাহাদুৰ আব্দুল লতিফ মিয়াৰ পৰা 1 নম্বৰ বাদীৰ স্বামী 2-3 নম্বৰ বাদীৰ পিতা সৰ্দাৰ লোহাৰ পত্তন লৈ চন খাজনা দি আদায় কৰি উক্ত মাটি দখল ভোগ কৰি থাকে। সৰ্দাৰ লোহাৰ বাদীসকলৰ ৱাৰিছ ৰাখি ঢুকাইছে আব্দুল লতিফ মিয়া পৰলোক গমন কৰিছে নিজৰ কৰাৰ পিছৰ পৰা তেওঁৰ দুজন ৱাইফ নেকি স্ত্ৰী আৰু ল'ৰাই সময়ে খাজনা দি লৈ আছে আৰু তেওঁলোকে বৰ্তমান বাদীক তফচিল বৰ্ণিত মাটি অসম চৰকাৰে অধিগ্ৰহণ কৰিছে আৰু বাদীসকলে নিজ স্বত্ব by operation of law অসম চৰকাৰৰ প্ৰজা হৈছে। নিম্ন তফচিল বৰ্ণিত মাটিত বাদীসকলৰ উত্তম স্বত্ব থকা স্বত্বেও যোৱা সেটেলমেন্টৰ সময় সেটেলমেন্ট কৰ্মচাৰী অন্যায় আৰু অবৈধভাৱে ভুলভাৱে খাস খতিয়ানভুক্ত কৰিছে আৰু এই মাটি গাঁও মানকাছাৰ দিহি মানকাছাৰ পৰগনা কৰাইবাৰী 1 নম্বৰ খাস খতিয়ানৰ 924 লৈছে ডাকভুক্ত কৰিছে গভৰ্ণৰ সেটেলমেন্ট মাত্ৰ ওই মাটি 1 বিঘা 1 কাঠা 6 লেচা হৈছে।
Now what it means?
They have taken Potton of 15 Chatak, Lordship. And it has become now 1 bigha 1 katha 6 lesa in government khas.
Government khas.
Yes, Lordship. So they admitted in that Sardar Lohar has taken Potton of 15 chatak only.
How much is 15 satak?
I have taken instruction from some old age clerks, Lordship, that 15 chatak is equivalent to 9 lesa only, Lordship. So their prayer, their plaint itself says that they have taken Potton of 15 chatak from Abdul Mia, Lordship. And this khas khatian bhukto was by wrong. It was their statement that Nibno Topsil Bornito Matit Badi Hokolor Uttom Sotto Thoka Sotto Jua settlementor Homoy settlement Kormosari Onnay আৰু অবৈধভাৱে ভুলভাৱে khas khatian bhukto কৰিছে আৰু ওই মাটি গাঁও মানকাছাৰ দিহি
By mistake.
By mistake it was made 924 dagbhukto কৰিছে government settlement ওই মাটি 1 bigha 1 katha 6 lesa hoise. But 9 lesa is not equivalent to 1 bigha 1 katha 6 lesa. So their prayer also, Lordship, in Topshil also they mentioned 15 chatak. Topshil, your Lordship will find page 66.
This is the plaint.
Yes. Lordship. Prayer is also there. Ko, kho, go. গতিকে বাদী পক্ষ প্ৰাৰ্থনা কৰে. That is the prayer, your Lordship has seen that prayer, Lordship. নিম্ন তফচিলৰ মাটিত বাদী পক্ষৰ বাদীগণৰ স্বত্ব দখলীয় প্ৰচাৰ কৰি word হৈছে এটোতো পঢ়িবই নোৱাৰি এখানে. গাঁও মানকাছাৰ 924 দাগৰ 1 বিঘা 1 katha 6 lesa মাটি খতিয়ানৰ পৰা বাহিৰ by expunging ওই মাটি বাদী পক্ষৰ নামত চৰকাৰৰ অধীনত এটা ৰায়ত খতিয়ান খুলিবৰ আজ্ঞা দি খতিয়ান সংশোধনৰ আজ্ঞা হয়. মোকদ্দমা খৰচ আৰু বাদী আৰু খতিয়ানৰ বাবে তাৰো আজ্ঞা হয়.
What prayer kho means?
গাঁও মানকাছাৰ 924 দাগৰ 1 বিঘা 1 lesa মাটি খতিয়ানৰ পৰা খাস খতিয়ানৰ পৰা বাহিৰ কৰি by expunging. So their contention is that they are the tenant under Abdul Khan Lordship over 15 chatak. So it was by mistake, it was converted to 924 khatian number 1 and measurement is 1 bigha 1 katha 6 lesa. So they claim for 1 bigha 1 katha 6 lesa. It is their statement in the plaint itself that by mistake it was converted to government khas. And Topshil they mentioned, Lordship, Gwalpara Porgonar Koraibari Dihi Mojar Chor Modhe Mrito Sardar Loharar Namio Musammad Halima Khatun Nurnehar Khatun Sami Mohammad Ilyas Gonor Mati Barshik Khazna Mut rate Aru Jomar 15 chatak mati. So in Topshil they mentioned 15 chatak mati jar uttore dokkine pube poschime. In Topshil also they mentioned 15 chatak.
Now read the second line from the
Barshik Khazna.
Barshik Khazana.
Mut rate niki iman aru jomar 15 chatak mati jar uttore thoka settlement দক্ষিণে রাস্তা পূবে PWD বাংলা পশ্চিমে নুরনেহার গং এই জমি যার বর্তমান সেটেলমেন্ট জরিপৰ গাঁও আৰু দিহি মানকাছাৰ 1 নম্বৰ খতিয়ানৰ 924 নম্বৰ দাগৰ একৱাৰ্ড মাটি হয়.
Okay.
Ekei mati hoy. So that 15 chatak was claimed, Lordship. So prayer portion, they have mentioned 1 bigha, 1 katha, 1 6 lesa. And in Topshil, they mentioned 15 chatak. And very beginning, they said that they have taken patton of 15 chatak only.
Okay.
So title court judgment, Lordship, in issue number 5, they have stated that the land council from their plaintiff side has argued. I was reading, maybe the plaintiff has examined as many as 3 witnesses. Page 81.
Yes.
In support of their claim, the plaintiff in his evidence in chief has stated that they had filed a suit bearing 61867 against the government as against the declaring the land under DAG number 924 covering the land 1 bigha 1 katha 6 lesa at village Mankasar to be khas land and obtained decree on 23/11/67, declaring title and possession and for correction of record of Khatian number 593 and DAG number 924. The plaintiff has exhibited Exhibit 4 as the decree of the against government in title suit number so and so. On perusal of Exhibit 4, through the suit of the plaintiff had claimed, though the suit of the plaintiff had claimed for declaring right title interest or on a land measuring 9 lesa and for that directing government of Assam for creating a separate Khatian by segregating the said land of 9 lesa from Khas Khatian number 1 and DAG number 924 and creating a separate Khatian. The suit was the declared ex parte against the government and accordingly a decree declaring right title interest over the suit land in favor of the plaintiff was passed and government was directed to create a separate Khatian for the said land of 9 lesa. Now on perusal of Exhibit 10, it is become discernible from the comment column that in compliance with the decree in title suit number so and so, the revenue records was changed and a separate Khatian bearing number 946 with respect to the land measuring 9 lesa was created in favor of the plaintiff and the land under DAG number 924 was included in the Khatian number 5. A separate Khatian was opened 946 and that was made Tolotia Khatian under Khatian number 5, Lordship. Similar observation had been made by the trial court while dealing with the petition of the plaintiff, praying for getting them impleaded in the title suit number so and so. On the ground that they were the actual owner of the alleged suit land and as such they were the necessary parties, but the learned court had rejected the petition on the ground that the suit land included in the Khatian number 5 is altogether different to that of the alleged land in which the right title and interest of the was declared in the title suit number 61867. So it is the view of the trial court also that the suit land of Lord.
He is informing that court time is over.
Oh, yes.
Okay, what is to be done?
Okay. After vacation, we all will forget.
Mm.
Day after tomorrow.
Yes, before we forget,
Lordship.
at least you should make the oral submission complete.
Lordship.
Then written submission you may submit at any time.
Lordship. So can it be fixed at 2, Lordship?
When?
Day after tomorrow, 3rd.
At 2 looks.
Okay.
At 2 it is better, Lordship. At 3.
Oh, yes, at 2. We will postpone other matters, new matters. Heard Mr. S.K. Goswami, learned counsel for the appellants. Also heard Ms. R. Chaudhary, learned counsel for the respondents. The hearing remained inconclusive. Let this matter be listed again for hearing on 3rd of October 2024 at 2 p.m. as per third matter.
Getting lots of, getting khosora, what is khosora? Giving.
Khosra means draft.
Dictionary of handbooks and other things also I have calculated. Draft.
Yes.
This handbooks.
Okay. After you make this, you have to address on substantial question of law also.
Yes. First, I'll point it out, they have empered only on the perversity, Lordship. So first I will,
Diversity as well as
Yes.
on limitation point also.
yes, Lordship. He is eagerly waiting to take your Lordship to the.
आज हमारा भी खबर लिया ये सब सीरियल वाइज बोला आज हमारा भी खबर लिया